the Rule 1A of the Assam Land Record Subordinate Service Rules. The matter ought to have been listed before the division bench, but it is listed as I.
You have SLD.
Yes, sir. Rule 1A of the Assam Land Record Subordinate Service Rules, sir. Okay.
Okay, I'll pass the order. Don't worry. Serially, when it comes, I'll pass the order. You need not be here. 43 to Halimonot Fuid. Yes.
May it be please your lordship. My lord, I beg to mention item number 13 of today's list. My lord,
13.
Learned Counsel Mr. R. Islam is on leave, my lord. Let the matter be taken just after vacation, my lord.
What is there in this matter? Huh? Just occupying space in our registry.
Just after
On the
vacation.
prayer is made on behalf of Mr. R. Islam, Learned Counsel, for the petitioner for an adjournment in the matter on the ground of personal inconvenience. Prayer is not objected to by the Learned Counsel for the respondents. Accordingly, registry to list this matter again on 20/4/2026.
Much obliged.
Wait, please, my lord. I'm appearing on behalf of SCGU, Mr. PJ Fokon. I beg to mention item 14, my lord.
Why? Why?
The petitioner has filed their affidavit in reply. Today morning only I have received it. My lord, I humbly...
Okay, we'll see. Let it come. We'll see. We'll see. We'll see when it comes. Be here when the matter is called.
May I please, I beg to mention item number 20, my lord. I want to withdraw it, my lord.
Why? Why?
My lord, my client instructed me to withdraw it.
Mr. K. Kolita, Learned Counsel, for the petitioner on instructions, submit that the petitioner desires not to press this matter any further. Accordingly, he prays that he be permitted to withdraw the present writ petition. Prayer accepted. Writ petition stands dismissed on withdrawal.
May it please your lordship. Lordship, I beg to mention item number 17 of today's list, lordship. I have taken consent from the other side, lordship. Some instructions is yet to be received from the petitioner.
You said that the pension proposal has been
Yes.
sent to the director of pension.
Yes, lordship.
We'll see what has happened. We'll see what has happened. The man's pension proposal cannot be kept hanging like this. Last time I remember you told
Yes.
me this. We'll see. Let the matter be reached. Mr. Bora, if you don't have instructions with regard to 17, kindly have your instructions.
May his lordship, with the
Please have a talk with Mr. Bora. Yes.
with the consent from the other side, I beg to mention item number 8, my lord, on behalf of PD Nair, my lord. He is out of station.
On the prayer of prayer is made on behalf of Mr. P.D. Nair, Learned Counsel, for the petitioner for an adjournment on the ground that he is presently out of station. Prayer is not objected to by the Learned Counsel. You have informed them, no?
My lord, my lord.
Accordingly, registry to list this matter again after the ensuing Bihu vacation.
Obliged.
Lordship, this is item number 2, which is listed for delivery of orders tomorrow.
Today,
Tomorrow. If this could be listed on the 24th of this month after BU, this pertains to
what is the matter?
Gauhati versus IOCL. This pertains to rejection of my candidature, Lordship, with IOCL.
It's only for delivery of orders. We'll deliver our orders. What is there? No further hearing is required. Hearing is concluded.
Let's conclude, Lordship.
Say tomorrow.
May it please, my lord. With regard to item number 14, my lord, I have filed one affidavit today, my lord.
Call it.
Requisition, my lord.
Call it.
Yes, yes.
Item number 21.
Yes.
Lordship, I've produced that instruction. I've given the instructions. Fine. So you find it.
Fine. That's the authorization, huh?
And then so much.
Yes, who is appearing for the finance now? Mr. Borpujari was appearing.
I have informed them, your lordship.
Why was this information not placed before this court on the last day?
Your lordship, my colleague appeared actually.
Whoever appeared.
She's on the way, your lordship. If your lordship takes it up after some time, your lordship.
So this information has been given now in after the order yesterday. Why this information was not received by you earlier?
She will be in a
That
better
11/9 the thing was sent, is under process.
position. Lordship, I have to ask your lordship.
Get the finance council also. Mr. Chetri, we have done something. We'll see what can be done. further. Hey, to get the finance council, Mr. Chetri, whenever you are free, tell her.
Yes. My lord, finance is here, your lordship.
Yes, this list was sent to you on 11/9/2025. You come to that second bullet, second bullet point. However, the proposal so-and-so, further queries, after some queries, so-and-so was submitted on 16/12/25. And what is happening? There is a clear-cut finding of this court.
I didn't had the occasion to go for
No,
this.
you said that no proposal is received. Recently some proposal had come.
That is what, because
You get your instructions. When you are
absolutely,
clear, come back.
absolutely.
Because you cannot now question the eligibility because this court has already, rightly, wrongly, dealt with it. Now you cannot sit over on appeal. You file an appeal against that order, you file a review, we have nothing to say. But today there is nothing. Determination already made. You cannot deny that to him. Just get your instructions.
Yes.
We will have it.
Yes,
Inform Mr. Chetri beforehand,
yes.
whenever you get it.
Yes.
Mr. Chetri, you take. Yeah. 14 to give. Oh. None appears for the petition on call. For the ends of justice, registry to list this matter again. After. The ensuing Bihu vacation reflecting the name of the standing council SSA in the, for the respondent in the boss list. Yes, what is your instruction?
DC was supposed to take instruction.
Ms. K. Fukon, no government advocate. Yes, Mr. Dhar, what is your instruction?
Thanks to thank government.
Okay. None appears for the petition on call. Registry to list this matter. For the ends of justice, registry to list matter after the entry. Bihu vacations. What happened? Nobody. Same order. When
Mr.
did, we
Rajman,
fix, when did we fix this matter?
24.
Do we have the petition number?
Yesterday's number.
Oh,
Yes, that's
जो कल था सिलसिले तो सोई क्या मैटर? Registry to list this matter again on. This तारीख है दिसुनी? No, not yours, not
20,
yours. Not
24.
20, not yours.
Oh,
20, 20, so 24, 2026 along with W.
1977
1977,
2026.
2020.
40.
Dekha. Heard Mr. T. Diori, Learned Counsel for the petitioner. Also heard Mr. S. Doctor, Learned Standing Counsel,
Revenue.
Revenue and
And
Disaster Management. Correct. The petitioner, by way of instituting the present writ petition, has presented a challenge to the provisions of sub-rule bracketed 1A bracket over of Rule 5 of the Assam Land Records Subordinate Service bracket amendment bracket over Rules 2003. Also, a challenge being presented to a rule formulated under section Article 309 of the Constitution of India, the matter is to be considered by a division bench of this court. Accordingly, a registry to examine the matter and list with the present writ petition before the appropriate bench. After appropriate bench, also as prayed for by the petition, Learned Counsel for the petitioner, that there is an urgency in the matter, registry to list this matter in the week starting from 2026 on a date to be fixed by it.
Tomorrow, if your lordship may kindly.
Time till 30th.
30.
And there cannot be a stay. It can be an examination.
Yes, sir.
On the week starting from 20th.
May I please? The petitioner was appointed between 1993 and 2001, my lord.
Now
Thereafter,
tell me, that act of yours, that absorption of yours in the T-post, that was not a permanent thing. It was just a.
more than 10 years of service, my lord. That had been done.
That was not there because there are orders of this court, my Lord Justice Gogoi's orders, which directed that now give them permanency, and accordingly the Assam Industrial Security Force was created.
That was created. After
Now, how can you claim that period?
That period, my lord, and suddenly in 2008, my lord, the committee was constituted. They were shifted to another.
No, they were not shifted.
They were absorbed, my lord, after
I tell
election
you,
process.
this all thing happened because of directions of this court. There are directions of this court. I forgot the case number, the name of the parties. There was a proceeding filed by persons similarly situated like you that give us some permanence. This court disposed of the matter, directing the government to take a decision. 2 battalions of AISF was created. Assam Industrial Security Force, number 3 and number 4.
That was the.
Then a decision was taken through the cabinet that all the Assam Tea Plantation Security Force employees, personnel, would now be screened.
Yes, that
Screening done,
That is the why notification dated 22/4/2018.
screening
That-
done, and then whoever found eligible were sent for 6 months training.
Yes.
On completion of training, they were absorbed as. But show me that your initial appointment was a permanent employment.
The initial appointment was because there was
That was just an
there was a
agreement.
situation, my lord, in the period and
That the
Insurgency
personnel will be
situation.
recruited payment by the tea gardens.
inside the situation. Only at this stage, lordship may issue notice, my lord. Let them
For
respond, my lord.
issuing notice also, you got to satisfy me. Your
Them-
prayer is,
That old pension scheme. They should be, since they have entered.
you show me that you were in a service.
Lordship, this appointment letter lordship will start from the annex of 1, my lord. Originally, they were selected from page 93 onwards, my lord. I have annexed the four persons. There are more than 200%. The 4
Now
persons.
show me what is your right. How
But
do you
since
claim that right?
They have entered service more than 10 years. And
Maybe,
suddenly in 2008,
But in where? In a home guard establishment.
that's it.
Show me that home guard establishment is entitled to pension.
At
That
particular,
force was covered by the Home Guards Act.
that particular point of the service has been taken because suddenly, my lord, 2008, my lord.
Sir, you got your absorption.
Yes, later on, that
Either
In
as it may, you
2008
got
that
something.
Committee was what, they were,
You got something.
screening was done, thereafter that. Then
Bihu. S. Bora. Heard Mr. S. Bora, learned counsel for the petitioner. Also heard Mr. R. Dhar, learned additional senior government advocate appearing for
Minor, I will appear for.
and also Mr. H. Alia, learned standing counsel, finance department. The petitioners herein have prayed for a direction upon the respondent, petitioners herein. Where is that order, impugned order?
there the impugned order, my lord. Lordship will find in page number 138, showing that there is no other person, 138, my annex of 6. Showing that there is no nil person in the battalion, madam. Appointed prior to the cutoff date.
The petitioners have, by way of instituting the present writ petition, presented a challenge to a communication dated 27/8/2025. The petitioners have further prayed that by reckoning the services rendered by them earlier in the Assam Tea Plantation Security Force as sepoys, SCPOYs, on their absorption in the Assam Industrial Security Force subsequently, the period of service rendered by them in 80 by কি লিখিছো আৰম্ভ? Then তাৰ আগৰ লাইনটো এনেকা লিখে, এইটো কাটি দিয়া. The petitioners presently are working as constables.
Not to,
Huh?
not to constable,
As constables
not to constable.
in the Assam Industrial Security Force on their such absorption occasioning in the year 2008-2009. Also, the petitioners have prayed that the petitioners be brought under the provisions of the Assam Services Pension Rules 1969 by reckoning the services rendered by them as sepoys in Assam Tea Plantation Security Force. Also, issue notice returnable 4 weeks. Mr. Dhar accepts notice on behalf of respondent number 1, 3, and 4, while Mr. H. Alia accepts notice on behalf of respondent number 2. As all the respondents are represented, no formal. The maintainability of the writ petition as raised by Mr. R. Learned, additional senior government advocate, is kept open. The question of maintainability of the present writ petition as raised by Mr. R. Dhar is kept open. Registry to list this matter again after 4 weeks. You check up those judgments. My lord, this Gogoi, huh?
Lordship, I'm very sorry, Lordship. Item 42 and 43, Lordship, I could not appear, Lordship. I was in the lakes, Lordship. Very sorry, Lordship.
We have not passed any orders. We have only directed in 42 to list it on 20th
Lordship.
and in 43 to list it before the division bench.
I'm very sorry, Lordship.
অলপ পিছত মাতি দিম।
Let it be after vacation.
What happened? Nobody is appearing?
Yes, sir, my lordship.
Second order ಮಾಡಿಬೇಕು.
अभी काम है, काम ही नहीं किस
Hello. Probably. Mr. Chetri, let him complete.
yes yes
Tour kita আছে pending. Pending আছে নি? Yes. ওটাতে retirement of people. Nothing more to submit. We have already declared, but today very hands are full from yesterday. We'll have it immediately after the vacation for delivery of orders. Hearing concluded. Registry to list this matter for delivery of orders. Khali date on there.
Earlier interim.
Earlier interim order to continue till the disposal of the present.
Always.
Yes, Mr. Dasgupta, any further?
So for the material on record, the last occasion, my lord, I have referred this Firestone's case there. Now, I would like to read out some paragraph, 2 or 3 paragraphs. Judgment is with your worship. Paragraph 32. Before, what is the law before insertion of section 11A? And you copy?
Para?
32. From those decisions, the following principle broadly emerge. The right to take disciplinary action to decide upon the quantum of punishment are mainly managerial functions. Before 1972, my lord. 71.
You're reading para?
Para 32.
From those decisions,
From those decisions.
the following principles broadly emerge.
Yes, yes. So before 1971, that is before insertion of section 11A, what was the law? From those decisions, the following principles broadly emerge. Number 1, the right to take disciplinary action and to decide upon the quantum of punishment are mainly managerial functions. But if a dispute is referred to a tribunal, the latter has a power to see if the action of the employer is justified. Before imposing the punishment, an employer is expected to conduct a proper inquiry. At the proper inquiry in accordance with the provision of the standing order, if applicable, and principles of natural justice. The inquiry should not be an empty formality. When a proper inquiry has been held by an employer, the finding of misconduct is possible. Conclusion follows from the evidence adduced at the said inquiry. The tribunal has no jurisdiction sit it in judgment over the decision of the employer as an appellate body. The inference with the decision of the employer will be justified only when the findings arrived at the inquiry are perverse or management is guilty of victimization or unfair labor practice or malafide. So the limited scope there was there. Even if no inquiry has been held by an employer, or if the inquiry held by him is found to be defective, the tribunal, in order to satisfy itself about the legality and the validity of the order, had to give an opportunity to an employer, an employee to adduce evidence before it. It
So
is
these things have already been decided in your case. The inquiry was held to be fair.
Hmm.
So there is no contrary material brought on record, even in the second, under the section 2 application, 2A application that you have brought on record. There is nothing brought on record to dispute that the inquiry,
Oh,
the penalty was not proper. There was not even an attempt made that.
no, it is not my case even.
Now your case is para 33.
Para?
33, section
Yes.
11.
The question is whether section 11A has been made any change in the legal position mentioned above, and if so, to what extent? The statement of objects and reason cannot be taken into account for the purpose of interpreting the plain words of the section, but it gives an indication as to what the legislature wanted to achieve. At the time of introducing section 11A in the Act, the legislature must have been aware of the several principles laid down in various decisions of this code referred to above. The object is stated to be that the tribunal should have a power in case where necessary to set aside the order of discharge or dismissal and direct the reinstatement of award and any lesser punishment. The statement of object and the reasons has specifically referred to the limitations on the powers of an industrial tribunal as laid down by the court and in Indian Iron Steel Company Limited. In the statement and object note, this case was mentioned. Then Millard 34 have some bearing. This will be convenient to consider the contents of section 11A. To invoke section 11A, it is necessary that the industrial dispute of a type mentioned therein should have been referred to an industrial dispute for adjudication. This is very important. In a proceeding under section 33 2B, the section power of section 11A cannot be invoked. It must be invoked when a dispute is referred.
But that issue here has already attained finality. Earlier, you have accepted that.
I do not understand what you are to
That 32, the application submitted by the employer was considered by the tribunal. And then it came to a conclusion that the inquiry was fair.
Yes.
Then the inquiry per se against you proceeded and an order was passed. You came up under 2A.
2A, subsection 2 of capital 2A, which is as good as section 10.
10. So now we are concerned with that proceeding.
Yes. And so to fortify this, Miller, so section paragraph 34 has some bearing.
Yes, please.
This will be convenient stage to consider the contents of section 11A. To invoke section 11A, it is necessary that an industrial dispute of the type mentioned therein should have been referred to the industrial tribunal for adjudication. Well, let us have the section 11A.
Industrial dispute.
Section 11A. নোটটা বার করো না, নোট ছিল একটা দেখো, দেখো দুটা নোট আছে। আমার না ওদের নোট।
Yes. Yes, Mr. Ross.
Oh, yes. Section 11 where? কোথায় গেল? Section 10. Section 11 where an industrial dispute relating to discharge or dismissal of a workman has been referred to a labor court, tribunal or national tribunal for adjudication. And in the course of adjudication proceeding, the labor court tribunal or the national tribunal, as the case may be, is satisfied that the order of discharge or dismissal was not justified. It may, by its award, set aside the order of discharge or dismissal and direct reinstatement of the workman on such terms and conditions, if any, as it thinks fit, or give such other relief to the workman, including the award of lesser punishment, in lieu of discharge or dismissal, as the circumstances of the case may require. Now, the proviso is very much important. Provided that in any proceeding under this section, labor court, tribunal, or national tribunal, as the case may be, shall rely only on the materials on record. Materials and shall not take any fresh evidence in relation to the matter. The what is the materials on record that has been explained in this case? I will place it before. Now, so from the contents of the section 11A is clear that when a dispute is referred to a tribunal or industrial labor court, and dispute must be a dispute regarding to dismissal or discharge and not others. If it is dismissal and discharge, then the labor code may look into the fact that whether the punishment inflicted on the delinquent was just and proper. Even this punishment was proved. Even the inquiry was fair. Then also
That aspect can be gone into.
that is the section that was inserted in the year 1971 in compliance of the International Labour Organization's regulations. Just throughout the world, this provision has been considered, inserted.
So now the materials on record, I think, has been dealt with in para 48, 49 of this
48, 44 almost.
44.
No, for the timing, let us keep up paragraph 41, 42. This is whether it is retrospective or not. Let us read 47 or what.
Proviso.
We will now consider the proviso to section 11, which deals with material on record. Mr. Deshmukh relied on the terms of the proviso in support of his contention that it is now obligatory to hold proper domestic inquiry, and the tribunal can only take into account on the material placed in that inquiry. That contention was negated. There no inquiry, even without holding any inquiry, employer can dismiss his employee, but he has to prove it in the labor court or the tribunal as the case may be. So this contention was negated in paragraph 47. The council emphasized that the proviso placed an obligation on the tribunal to rely only the materials on record, and also prohibits the tribunal from taking any fresh evidence on relation to the matter. According to him, the expression material on record refers to the material available before the management to a domestic inquiry, and the expression fresh evidence refer to the evidence that was being adduced by the employer for the timing before the tribunal. From the wording of the proviso, he wants us to infer that the right of an employer to adduce evidence for the first time has been taken away, as the tribunal is obliged to confine its scrutiny only on the materials available in the domestic inquiry. According to the material which was placed before the domestic inquiry should be considered.
That has been negated.
That has
Para
been negated by the court.
49. Now, in para 48, 49, along with that material, evidences which have come before the court will also be a material on record, and the tribunal can look into it for the purpose of determining whether the proportionality of the punishment.
Yes,
is
correct.
Now, in your case, there is no material.
No. My case, 2 witnesses were examined.
But they have not brought on record anything.
Yes, they have brought on everything. They have brought the settlement and the other things also.
But Mr. Dasgupta, this is a clarification doubt.
Hmm.
The settlement had certain stipulations
Yes.
that you do it in this manner, it will be.
Yes,
the
yes, that is the
consequences
main
would
point.
be there.
Now let us come to the facts of it. Settlement contains certain clause that if you are to comply with these provisions, then and only then you can
Reinstate.
reinstate. And if you do not comply with that,
That
you
too-
are not entitled
That too
to.
with prospective effect.
That will be a prospective effect. That is the case. The whether the settlement was duly complied with or not. It is the categorical finding of the labor code that no, settlement was not finding on the labor code, and for that reason, you are not entitled to have a reinstatement. That was the finding. Now, Miller's one thing that has to be considered now. Yes, settlement has been violated. Let us consider. But we have not complied with the settlement. Or merely because of non-compliance of the settlement, whether the workman is not entitled to be reinstatement or with some lesser punishment. That aspect has to be considered by the labor code because it is a part of the material on record and it is the only material that has to be considered. So for the other misconducts are concerned, that has gone away by dint of a settlement. Now we have, according to them, that you have not filed a joint application before the presiding officer, where the proceeding under section 33 is being conducted. So as you have not filed this agreement, so you have violated, so you are not entitled. All right, let me assume that I have violated this thing, but we have not approached. No joint application was filed. Or the employer has not, our case before your lordship would be the employer has not come forward. Their case before your lordship would be the employee has not come forward. This may be allegation and contradiction. Let me assume that this settlement was violated. So even assuming that this settlement was violated, whether for that reason, whether the punishment inflicted on them can be invoked, can be considered or not, that aspect of this case is required to be examined. Now the learned presiding officer was of the view, as tribunal has held that the inquiry was fair, so we cannot pass any order of reinstatement.
Simple as that, yes.
So he has not considered the material on record. That is my humble submission before your lordship. And I think that this matter can be remanded back, or your lordship can also examine this matter. Because High Court has some power. So it would be better to remand the matter if your lordship desired to do so. And on the last occasion, Mr. Tewari also considered this thing.
Okay. We'll examine this. The scope is very less. Very narrow compass, we'll have to examine.
Yes,
Better,
no.
now I get your point that what you were trying to highlight on the last date, today it's clear.
No.
What you wanted to say is that this settlement being a material on record, you ought to have examined it as to whether the violation notwithstanding, whether the inaction on the part of the management also to take it forward would have required a relook in the penalty.
That is one aspect, as you say. And second aspect is that when the labor court or the industrial tribunal, as the case may deal with such type of cases, the labor court or the industrial tribunal must consider whether the section 11A is applicable or not. But he has not made any such endeavor whatsoever. There are some cases, if required, I can bring. It is the mandatory provision. He must address himself on the contents of the section 11A.
Correct.
And for that purpose, your scope is very much limited. You must consider on the material on record only.
And material on record now has been clarified first.
First. So, and you cannot go beyond that.
Correct. We'll examine. But the parties at length, hearing concluded, registry to list this matter again on 7/5/22. Itna beleg na deliver. Delivery for that. 7/5. We'll deliver the order on that.
In the last occasion, I gave a note, of course. In that note, I have referred to one or two judgments.
It's there. We'll look into it. We'll look everything. Don't worry.
No, as you has understood I am not at all.
Understood.
No, I am not at all audit.
Don't have any presumptions of that. I'll have to read. Yes, Mr. Dega.
Extremely sorry, my lord, with regard to item number 40, my lord. Chief is passed an order and none appears, my lord. I was on legs in court number 1, my lord.
What happened to your other colleagues?
They were also not there, my lord. Extremely sorry. In fact, these similar matters are being considered by a coordinate bench, my lord, and the matter is fixed on 14/5, my lord. In fact, my learned senior friend Ashish Dasgupta sir is appearing.
Okay. Item number 40. Mr. N. Datta, on counsel for the petitioner. Mr. Deka submits that the issues arising in the present petition also arises in the proceedings of WPC number
5823 of 2020.
5823 of 2025. Raised to list this matter along with WPC number
5823 of 2020.
5823 of 2025 on 14/5/2026.
Only thing, my lord, there is an interim order that no coercive action should be taken against the.
Then we'll have to issue a notice here.
Yeah, but because I have the interim order with me. Case of withdrawal of the benefit of higher pension.
To that extent, maybe we can.
Lordship.
Okay. It will book the reverse. I'll just go through it.
My-
We'll pass.
my
it.
pleasure.
14/5, no?
14/5. The next date is not there, my lord. I've checked the status of the cases along with several other writ petitions.
Have not factored this. You understand, no? A little bit understanding only, so I'll have to go through this. We can file to move deep.
Acknowledge.
There. Yes. Mr. Borpujari, what has happened?
Yes, my lord, I have taken the instruction. My lord, along with the petitioner's proposal has been received in respect of several other persons. My lord, it is over more than 50 to 100 persons. Now the department is taking a wholesome, my lord, view of the entire matter, and the entire log will be, my lord, cleared after, my lord, 4 weeks. It will take an amount of the time of 4 weeks. That is what, my lord, I have been told. Because of, my lord, the present electioneering process, my lord, these officers are
But
also
when
busy.
the proposal had come to you, you said that it came just the other day. Now that's why we were cross with her.
No,
Now
my lord.
this proposal was sent on 11/9, final proposal on 16/12.
No, 16/12, thereafter also, my lord, some queries were raised.
That
my
as
lord.
it may.
Yes, yes.
What are
Now-
the queries
now-
you are asking?
Now,
What are the queries you are asking?
now, my lord, I have taken the instructions. We are required to take a stand. My lord, take the call, my lord, of granting, my lord, the minimum pay scale.
You
And that
don't
will be
have
done.
that protection. You don't have that. That this court has already taken
No,
that.
my lord, we will be doing it. It is not that we will not be doing it. We'll be doing it. They are only seeking for some further time of 4 weeks, my lord. Because, my lord, it is not only the petitioner, my lord. Several other persons have come, my lord. So therefore, my lord, it has to be placed, my lord, before the
We are not concerned with the others. We are concerned with the petitioner.
Lordship is also
Naturally.
absolutely correct.
Why should
Yes,
we take-
Yes, yes,
Our orders is for the petitioner.
absolutely.
And that is very clear.
Absolutely. No, my
And
lord,
there is a deliberate violation of this now.
they have received it, my lord. They say, my lord,
Mr. Borpuzari, you take your call. There is no problem in that.
No,
If
my lord.
this order is wrong, go up before the higher forum.
that is
But
absolutely
This
not.
order
Ab-
was passed on 24/2/2021.
That is why, my lord, they are in the process of compliance. My lord, they are only seeking some accommodation, my lord. Only to that extent, my lord. It is not the case, my lord, that we have received the proposal. We are seeking.
Now,
over
first
it.
the file came to in 21, then in 22, then there is a lull, then it goes up again in 25. What is this manner you are dealing with the High Court orders?
No, my lord, this because the particulars will have to be, my lord, furnished so that.
If not, where is your communication that this is not there, this is not there? Where is that?
My lord, those.
And this case is pending from 24. And the notices in this case was issued on 22/1/2025.
Yes.
And you had duly received your notice. And thereafter, nothing.
That we only received the communications, my lord, instructions on, my lord, 12th of December 25. Then,
No,
my lord,
you
the-
you had received these notices on 22/1/25.
Yes, my lord, I have both the instructions with me, my lord. One is dated, my lord, 12th of December 25, and the latest one is, my lord, 3rd of March, my lord, 2026. Both, my lord, say, my lord, that after receive, it is under process for a final decision regarding grant. So it will be done, my lord. It is not that, my lord, they will not do it.
Who are you to take a decision? You have to
No,
just
my lord, the
comply.
language is as such, my lord.
Be that as it, you
Yes,
have
yes.
to just comply.
Yes, yes,
And if
absolutely.
there is anything,
Yes, yes. yes.
go up before the higher
No,
forum
my
or go
lord,
to
no.
the court which passed.
That
the
could
order.
not be the intention of the department, my lord. They will have to comply. There is no way of any escape, my lord.
And a date has also been spelled out, 1/8/2017. Only thing whether he works for 10 years, that they have clarified. Finished, that's the end of the matter.
They will be doing it, my lord. This is what, my lord, I have been instructed, my lord, to pray for it.
Okay, who
For
is
which-
the authority who is now dealing with the matter?
My lord, it is the commissioner and secretary, my lord.
So we would like to know how I is sitting over the file from 12. This is 6 तारीख ना? 8 तारीख. The Ms. U. Sharma, learned government advocate, has on instructions submitted that in pursuance to the directions passed by this court-wide order dated 24/2/2021 in WPC number 2847/2018, a proposal for release of minimum scale of pay to the petitioner and 43 other similarly situated master role /casual employees were forwarded to the Finance Department for its concurrence initially by an endorsement dated 5/8/2021. However, the same was returned by the Finance Department with some queries. The queries were met and the file was re-endorsed to the Finance Department. However, the Finance Department regretted the proposal wide endorsement dated 7/4/2022. Thereafter, there is a lull in the matter. Thereafter, it is seen that there is no processing. Thereafter, in terms of the instructions received by Ms. U. Sharma, there was no processing of the matter. And on 11/9/2025, the Department of Women and Child Development had again moved the Finance Department in the matter with a again moved in the matter. Also, after meeting the queries raised by the Finance Department, the proposal was resubmitted again to the Finance Department wide an endorsement dated 16/12/2025 for their for its concurrence and approval. However, no response was received thereafter from the Finance Department. Mr. R. Borpujari, Learned Standing Counsel, Finance Department submits that the Finance Department is processing the matter for a decision, for arriving at a decision whether to grant the minimum pay to the petitioners. In view of the order passed by this court, in view of the directions passed by this court, wide order dated 24/2/2021 in WPC number 2847 of 2018, no authority would now have the jurisdiction to examine as to whether examine the entitlement of the petitioner to receive the minimum of the pay scale prescribed, inasmuch as the said aspect of the matter on consideration was determined by this court. Also, this court had also required that the petitioner and other similarly situated persons be extended with the benefit with effect from 1/8/2017. Also, it is seen that the respondents are not processing the matter for compliance of the directions passed wide the order dated 24/2/2021, and a delay of more than 5 years have occasioned in the matter. As a last chance, the respondents are directed to comply with the directions passed by this court by the said order dated 24/2/2021 on or before 11/5/2026. In the event the said order is not complied with, the Commissioner and Secretary, Finance, Department, as well as the Secretary to the Government of Assam, Department of Social Welfare, Department of Women and Child Development, shall appear in this before this court on 15/5/2026 at 10:30 a.m. to receive further orders in the matter from this court. We'll drop contempt proceedings. That's all left now.
Lordship has fixed for their, my lord,
You have to comply within 11/5 and the appearance is on 15/5.
Published.
May it please your lordship. Lordship is directed to obtain instruction regarding the settlement process, my lord. My lord, last, my lord, subdivision advisory committee that was held on 23/2/2026, my lord. And next meeting can be convened, my lord, after the election result, my lord.
So what did you do till now?
My lord?
What have you done till now?
No, that earlier, my lord, proposal sent by the concerned settlement officer, my lord.
Officer, that
Then
was placed before.
We are directed him to submit before, again resubmit, my lord. He has submitted, my lord. Now committee have to decide, my lord.
No, that proposal was submitted long back.
My lord, my lord.
22, what happened?
20
That was not considered by the subdivision committee.
23, my lord. 9/1/23, my lord. Is submitted,
That was
my lord.
not considered by the subcommittee.
My lord. On 22/3/26, my lord, that has not considered, my lord.
Why?
That instruction, my lord, I have to take because, my lord, just now I got.
None appears for the petitioner on court. Mr. P. Soikia, government advocate, submits that the instructions received are not complete and accordingly prays that the matter be taken up after the Bihu vacations. On which date, to facilitate him to complete his instructions in terms of the complete his instructions with regard to the manner in which the proposal for allotment or settlement of land in favor of the petition number 1 school was processed by the respondent authorities. But Mr. H.R. Ahmed, Learned Counsel for the petitioner, report none again.
Mass oblige.
Lordship, Lordship, kindly look at order dated 9/2/2026. Kindly look at the order 9/2/2026. Here it was instructed for the respondent to file an affidavit. Respondent is here to file an affidavit.
No, Lordship, the affidavit is ready. Lordship, yesterday the swearing letter has been sent, so it will be signed in a few days, Lordship. And otherwise, the case here is, Lordship, the unauthorized absence, and basically the theft part, Lordship. I have not seen in our listing any PS case has been raised in regard to theft.
On the prayer of the learned counsel for the parties registry to list this matter after the ensuing vacation.
Mass oblige.
None appears for the petitioner on call for the ends of justice. Registry to list this matter after the ensuing. vacations. So K. Parasar, learned. CGC appears for the respondent. Go.
I am assisting counsel.
Yeah. এইকেইটা মাতা 1 নম্বৰ টপ অফ দি লিষ্ট হৈ গল নেকি শেষ কৰিলো None appears for the petitioner on call. It is seen that on the last date of listing, that is on 13/3/2026, there was no representation on behalf of the petitioner. Accordingly, the present petition stands dismissed for non-prosecution. Yes, what has happened here?
Lordship, SC finance has to take instruction, Lordship.
Mr. Borpujari was here.
Yeah.
Get Mr. Borpujari.
Lordship,
Mr. Dev, wait for some time.
I was with item 7. I just had to attend a call. I was called at code 25.
Yes.
12.
As prayed for by the learned counsel for the parties registry to list this matter again after the end.
My lord. On 7, I was present. My lord.
You are not present on 7.
My lord.
You are not present on 7.
I was there, my lord. Just went out for a
I
moment.
can't, I don't have that X-ray eyes to see outside.
Because my lord was, I was expecting that because the list was called in a serial manner, but
We call it, this list is there, I can call anything, but I am
That-
doing it in a seriatim manner.
my-
Every head I am taking.
no, but we had to also to my lord adapt to that, my lord. So I had to rush outside. My lord, kindly
Right.
right.
For the fault on the part of the court, the learned counsel not being available,
My fault, my fault.
the order is recalled and name of Mr. D. Gogoi is shown as to be heard. Will do.
My fault, my lord.
Not my fault. Heard Mr. D. Gogoi as agreed to by the learned counsel for the parties agreed to list this matter after the ensuing. vacation.
Public. my lord.
Yes, Mr. Borpujari, any instructions?
Yes, my lord. No, then amount of rupees, my lord, 33,132 that has been, my lord, paid to the petitioner on account of GPF. Now, my lord, here is a case where, my lord, at the time of his retirement, my lord, he was making contribution under NPS, but there was a dispute whether OPS or NPS. Now, because of the dispute, my lord, the NPS contribution could not be credited to his account. Now, my lord, the concerned office, that is the Office of the Director of Accounts and Treasuries, they have moved a proposal before the Finance Department to issue a notification, my lord, inscribing guidelines what to do in this kind of situations, my lord. And that is
But
awaited.
what will happen to the poor man? His money is held up.
It will be paid, my lord. It is not that it will not be paid. Because had it been a case, clear and plain and simple case of NPS, by this time
When
we
did
would
you
have.
retire, Mr. Deb?
19, my lord.
2019.
31st of March 2019.
And Mr. Barpuzari, 2019, and today we are in 26. And this man is hanging for his man. You have given him pension. You are getting pension.
But my lord, we are getting pension.
So now what DCRG?
NPS.
NPS dues.
Only his contribution
Yes,
part.
My lord, my
What is the
contribution
amount?
only,
What is the
they have
amount?
contributed
What is the
3
amount?
lakh something loss. 3 lakh, 3 lakhs.
around 4 lakhs.
4 lakhs.
This will be paid, my lord.
So we'll give it to you. Let them that they are doing a good thing. That they are going to, because of you, others will also be benefited. Let them take that call. Let them issue that notification. And Mr. Dave, 4 lakhs. You are a banker. You
My
tell me what interest and what the amount would be on the next day. We will pass that on. Mr. Dave is a banker, you know that. Be careful.
My lord, next date can be in the second week of May, my
Okay.
submission. Okay.
Mr. R. Borpujari, Learned Standing Counsel, Finance Department submits that the matter pertaining to release of the NPS dues, NPS contribution made by the petitioner is at an advanced stage, and the Director of Accounts and Treasury, Assam, has approached the Finance Department for laying down a guideline for the purpose of release of such dues wherein the person concerned, although contributing to the NPS, was later found to be entitled to be extended with the pension under the Assam Services Pension Rules 1969. He submits that the said notification guidelines being laid down would benefit the others also, and accordingly prays that the matter be taken up on. When will you get that?
That can it be in the
May.
second or third week of May, my lord?
Third week of May. On 19/5/2026.
19/5, yes, my lord.
On the next date of listing, the guidelines shall be placed before this court along with the order authorizing the petitioner, the reauthorizing the petitioner, the contribution so made by him towards his NPS account. On the next date of listing, this court would consider the interest that would now be required to be attached to the amount involved for the delay occasioning in clearing, in reauthorization of the same to the petitioner herein.
Right.
That's good.
But Mr. G.R. Datta, Learned Counsel for the petitioner. Can have your seat, Mr. Suresh. Also heard Mr. Ms. H. Tarang, Mr. P.P. Datta, Learned Standing Counsel, Department of School Education. Anyone more? And Mr. P. Soikia, Learned Government Advocate. Also, the petitioner, by way of instituting the present petition, has presented a challenge to an communication dated 28/4/2017, issued by the Director of Madrasa Education Assam, requiring the principal, GK Arabic College, Gunial Guri, Porpeta, to withhold the pay and allowances of the petitioner with effect from April 2017. Also, further, why they said communication, the principal, GK Arabic College, Gunial Guri, was asked to prepare a detailed statement with regard to the salaries and other allowances drawn by the petitioner with effect from 1/12/2015 to 31/3/2017. Para. The petitioner in the present petition has projected that during the period 1971 to 1973, he had prosecuted his studies in Gunialguri ME Madrasa. So, after completing his studies, after completing his class 6, after completing his class 6 standard, the petitioner proceeded to enroll himself in GK Arabic College, Gunialguri. Both the Gunialguri ME Madrasa and GK Arabic College were functioning from the same premises. It is projected that there being a vacancy arising in the post of menial in the college, the managing committee of the college proceeded to engage the petitioner as a menial also in the year 1974. Such engagement is said to have been so made basing on the class 6 pass certificate produced by the petitioner. It is to be noted that when the petitioner was so engaged as a menial, the college in question was, the GK Arabic College was in its venture stage. The petitioner further projects that in terms of his such engagement, he joined the post on 8/1974. Also, the petitioner thereafter projects that he had appeared in the Assam Madrasa, intermediate examination in the year 1981 and had cleared the same in the second division. Mr. Goswami, this will take some time. There are 3 matters. We'll have to dictate the orders. That
if it my lord doesn't inconvenience your lordship, my lord, can we have my lord, a slight accommodation for the day, my lord? We can have it immediately. I wanted to make a note, and I have come across.
You only have to give me some judgments.
Some judgments also are there, my lord.
I have also researched and got out something.
Yes, I've got some 2-3 judgments, my lord. But can we have it immediately reopened or any day your lordship wants? But as a further hearing, my lord. My lord, my friend is here.
I'm here.
I tried to contact him. He's not picking up the phone. I have got some.
He has blocked you.
No. All right, my lord.
Item number?
18, man.
18. As prayed
Your
for by
lordship
the learned counsel.
also prayed for that I should submit the what call my lord
Issues.
I have got that, my lord. I can submit that, and along with the written statement where they have
no
taken,
injunction till now.
No. My lord, where they have taken the plea of this 145 also in the written statement. That is also in the domain of the civil court.
The executive magistrate's order is covering till the competent court.
They have gone through it.
Yes. I can submit those documents, my lord.
It has dealt with every aspect under the sun.
Yes.
As agreed to by the learned counsel for the parties, as prayed for by the learned counsel for the parties, to listen again on. So, you can give the issues.
Yes, issues
That
as
has
well
been
the written
framed.
statement.
It's in order form.
But yes, it's an order form. Certified copy I'll give.
Just give a Xerox copy of that.
Well, one copy to me also, man. I haven't got it. Here.
Your client will give you that.
He has it, man. One copy.
Even the WS also I give.
No, WS already issued.
Sorry to interrupt. WS, there is this 145 proceeding.
The only thing is that in the proceedings before the executive magistrate or in the
revisional court,
before the sessions court,
yes, no.
although he had made categorical statements in the petition as well as during the hearing, that he had bought the land from you, a part of your land which you bought from your vendor, a part he had brought, and he had constructed a house there and he was occupying there. This factor was never disputed by you. You did not even touch that.
Yeah. That's the issue.
Huh?
That's the issue.
You did not even touch it. It is only by filing the first suit, you build up the groundwork to bring in the second.
Exactly, man. That limitation, covering up the limitation.
It's not that, my lord.
I'm trying to learn.
No, your lordship is already in session of this one.
That is
But
the
that's not the
first suit,
fact. Fact is, my lord, that I have already constructed with the permission of the
I
three-story
got
building.
it. I got it.
And by
But the
second
plea
thing-
that now you are taking, see, this plea was there
Yes.
that because you say I did not know till the thing had come, but the moment the notices were there in the hearing, it was his specific plea that this is the land bought by me. Probin Borough was staying there. Probin Borough was chased.
Yes.
So that's how he built up.
He
Maybe
built up.
he is the land grabber. We got
He's
it.
the land grabber.
But where is that plea?
My lord, in the title suit, I have categorically
And in
stated.
first title
and-
suit,
Yes, my lord. Only one title suit, my lord.
there are two.
No, my lord. Only one title suit. If I'm not wrong, my lord.
There are two.
What,
titles.
2018?
18, there's a title suit. In 2018, my lord, there's a title suit. In 19 also,
There is one.
there is a one, my lord.
Ah.
Right, my lord. In the title suit also, the same plea was taken regarding the sale deed.
No.
Yes, my
Sale deed came in the second title.
Exactly,
yes, my
man.
lord.
The
Between
second
the
suit.
second time.
In the first one, there is nothing.
Nothing, my lord. In the second
That
time,
was
I
to
have-
get over that limitation, man.
no, my lord. I have challenged the sale deed because of the fraudness.
I got it.
That is, sir.
See,
And my lord, there's
Mr.
another
Mr.
aspect.
Mr. Bhattacharjee,
My lord, there's
subject to
another
correction.
aspect
No,
I'm telling you, my
subject
lord.
to correction.
Yes,
This fraudulent sale deed
yes,
was to your knowledge
yes,
when it was brought to the notice of the magistrate during the inquiry.
yes. my
It
lord.
is reflected in the order.
Yes, yes, order.
The suit is subsequent there.
Yes, my lord.
But therein this challenge to the sale deed is
Well,
not there.
The suit was of the 19, and when the
No, 18 suit.
18 suit, my
There
lord,
is
I
no
agree.
challenge.
Not challenge. What about the 19? When they filed the writ petition, my lord,
Writ
they filed
petition.
in 22. When the session
24.
title suit was in 19. This for after the lapse of 4 years.
But
Why?
in 19 years, there is a challenge
That's,
to the.
then why my after 4 years? Why not immediately they have come?
And why did you not challenge it immediately? If that is a fraudulent sale deed.
See, my lord, one thing, the question of the fraudulent, when it come to our knowledge,
It came to your knowledge on the day
yes,
when
my
the
lord.
executive magistrate.
Because that is
proceedings
the
was there.
procedure going on, my lord. This is the advice of the advocate, the learned advocate of the lower court.
Same
my-
here. The advocate
Yes,
did
yes.
not advise.
My lord,
Mr.
I am on the law
Fine,
points.
Mr. Ghosh.
I am on the law points, not on the facts. When these issues, which was been framed, and in the written statement, they have also stated that 145 proceeding is there, whether the
Oh,
court
yes.
can adjudicate that matter. That is the issue, my lord. I have no objection to that. If your lordship pass the order, that's fine, my lord. Because the issue is there, and they have, in the written statement, they have raised this question also, 145. Now, it is in the domain of
You
the,
had not filed any injunction application.
no, my lord, because I am in
You are in
position.
possession.
I am in position. Why should I? The question, entire question is about the sale deed, my lord.
Now, whether he has filed any counterclaim.
No. He only filed a written statement.
He has
LSE?
not sought for any direction for the possession there.
No. He is only asked that
The
my,
possession was already
Already
declared.
declared.
Already declared.
my lord, whether that position is valid in the eye of law. When
There
that,
are-
when the
there are-
sale deed is, when
There
the
are
sale deed is,
Judgments.
yes, there is judgment, my lord. When the sale deed is, when the sale deed is under challenge.
Next day, Kiman,
Save something for the.
No, no.
you can give that.
That is lordship. I'll pass it.
Sorry to mention, my lord. Item number 47, my lord. I am some medical emergency, my lord. I got call from my home, my lord.
Please go.
47.
Mark quit video.
Interim order may be continued, my lord.
Item number 47. You are 40?
Petitioner, my lord.
Mr. J. Oscar, learned counsel for the petitioner submits that he would require an accommodation in as much as there is a urgent medical, a medical emergency has arisen in his family and he would have to leave the court. So prayer is not objected to by Mr. S. Islam.
No, my lord.
No, no.
P. Chakravarti.
The prayer is not, you have informed the others.
I'll inform my lord. Suddenly.
Okay. Prayer accepted, registered to list this matter again. After the ensuing, again on 24/4/2026, interim order passed earlier to continue till the next date of listing. Eto serially mati diba.
Obliged.
I'm sorry, Your Lordship. I think 10 years, Your Lordship pass an order. I'm directing another court for non-procedure. Take up a 2 year, Lordship.
Okay, 10. Okay, recall koriba. Ito dia bisa order dia bisa 10 mati diba.
Obliged.
Dekha. Kila. Second division. Also, but it is further projected by the petitioner that on clearing the Assam Madrasa intermediate examination, the governing body of GK Arabic College in its meeting held on 27/7/1986 resolved to appoint the petitioner as an assistant teacher with effect from 1/8/1986 for its pre-senior section. Accordingly, the petitioner joined in his services as an assistant teacher with effect from 1/8/1986. Also, the petitioner further projects that in the year 2015, certain vested interest had raised objections with regard to the age of the petitioner. Also, it is projected that an inquiry was carried out in the matter by the Director of Madrasa Education Assam. And in the said inquiry, it was found that the date of birth of the petitioner recorded as 1/12/1960 in his service records were correct and the same was not mandated to be corrected. Was not mandated to be altered. Also, the petitioner projects that in the Assam Madrasa intermediate examination certificate, the age of the petitioner was recorded as 19 years, 3 months, 0 days as on 1/3/1980. And by computing the date of birth and from the said and a computation made basing on the said age, the date of birth of the petitioner works out to 1/12/1960. So apostrophe between. Also, it is under such circumstances that the Director of Madrasa Education proceeded to issue the impugned communication dated 28/4/2017, requiring the principal GK Arabic College to restrain the petitioner from attending the college and also to hold up, to withhold his salaries with effect from April 2017. The petitioner projects that the age of the petitioner has that by reckoning the age of the petitioner as 1/12/1960, his date of superannuation would fall on 31/12/2020. However, the respondent authorities have arbitrarily forced him out of the college with effect from 1/4/2017. Also, accordingly, the petitioner has instituted the present petition. Mr. G.R. Datta, Learned Counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that after the passing of the order dated 28/4, after the issuance of the communication dated 28/4/2017, the petitioner had approached the headmaster Guniali Guri Emi Madrasa for procuring his class 6 pass certificate, inasmuch as the same was required required to be submitted before the departmental authorities in terms of the communication dated of the impugned communication dated 28/4/2017. The application submitted by the petitioner was responded to by the Headmaster Guniali Guri ME Madrasa via the communication dated 12/6/2017, wherein it was stated that, wherein it was highlighted that on account of a flood occasioning, on account of floods, on account of devastating floods occasioning on 15/9/1984, the documents as maintained, records as maintained in the school were washed away, and the same is presently not traceable. So, as such, it was highlighted that it would not be possible to issue any certificate to the petitioner in absence of the records. Also, the petitioner brought the said matter. It is further projected that the petitioner had brought the said aspect of the matter to the notice of the Secretary, Assam State Madrasa Education Board via the communication dated 7/1/1986. Also, Mr. Dr. has further submitted that the date of birth of the petitioner as recorded in his Assam, in the Madrasa Intermediate Examination, it's called Assam Madrasa Intermediate Exam.
Yes.
Intermediate Final Examination. Assam Madrasa Intermediate Examination, 1981, was so recorded basing on the earlier school records of the petitioner, and the date of birth as working out from the age disclosed in the said certificate works out to 1/12/1960. He submits that the date of birth as working out from the Assam Madrasa Intermediate Examination certificate is to be given primacy, and the same is mandated to be so reckoned for the purpose of determining the date of superannuation of the petitioner herein. Mr. Dr. further submits that although the petitioner earlier had approached this court by way of instituting a writ petition being WPC number 3204/2017, claiming the arrears of his salary, the same was withdrawn basing on an assurance given by the departmental authorities for releasing to the petitioner his arrears, his area salaries. Also, however, Mr. Dr. submits that the area salaries of the petitioner had not been released. He submits that the approaches made by the petitioner for his reinstatement in service, for permission to resume his services and also for release of his arrears of pay not having been considered, the petitioner was required to approach this court by way of instituting the present writ petition. He submits that the petitioner's age in terms of the records maintained by the Assam State Madrasa Board being 1/12/1960, the same would not be permissible to be altered by the respondent authorities. Mr. Dr. has further submitted that in the service book of the petitioner, the date of birth, his date of birth has been recorded as 1/12/1960, and the same is also found to have been endorsed by the Director, Madrasa Education Assam, vide his endorsement dated 30/7/2015. In the above premises, the above premises, Mr. Dr. submits that the petitioner being restrained from continuing with his services after, with effect from 1/4/2017, the petitioner is entitled to draw his salaries and other allowances with, is entitled to be authorized his salaries and other allowances with effect from 1/4/2017 to (31/12/2020), that is the date of his actual superannuation, his services. Mr. Doctor has further submitted that the petitioner has also not been authorized his due pension and pensionary benefits, although the petitioner has proceeded as per the date of birth in his service book on retirement with effect from 31/12/2020. Anything more to be added? Nothing? Per contra, Mr. P.P. Dr. Learned Standing Counsel, Elementary Education Department, submits that the contemporaneous records maintained pertaining to the service rendered by the petitioner as a menial in the GK Arabic College reveals that the date of birth of the petitioner is 1/12/1955. Jo date of birth kuchu and not 1/12/1960. Mr. Dr. submits that in the particulars of the teachers, particulars of the employees working in GK College as submitted in connection with the deficit grants of aid granted to the college, the age of the petitioner as on 1/3/1976 was reflected as 20 years, 3 months, 9 days. Mr. Doctor submits that the same was so done basing on the disclosure made by the petitioner at the time of his engagement as a menial, that is, on 1/8/1974. He submits that considering the age of the petitioner as on 1/3/1976 as disclosed in the said particulars, the date of birth of the petitioner works out to 22/11/1955. He further submits that the said date of birth, that is 22/11/1955, has also been reflected in the other particulars, other records of the employees. Other records of the petition are maintained in this connection, like the online details of the employees of the college in question. Mr. Dr. submits that considering the date of birth of the petitioner as 22/11/1955, his date of retirement would work out as 30/11/2015. Mr. Dr. submits that the date of birth of the petitioner as recorded in his Assam Madrasa Intermediate Examination Certificate, as well as in his service record, is on account of a misrepresentation made by the petitioner in the matter while filling up his form for the said examination. He submits that in the event the date of birth of the petitioner is construed as 1/12/1960, on the date he had joined his services in the college as a menial, that is on 1/8/1974, the petitioner would be aged around 13 years, 8 months. That is, the petitioner would be a minor. So he submits that the said position is not permissible, submits that a minor is not permissible to be engaged in a government recognized institution However, he submits that the said position had not occasion in the matter inasmuch as the petitioner on the date of his engagement as a menial is found to have been aged about 18 years by construing his date of birth to be 22/11/1955. Accordingly, in the above premises, Mr. Datta submits that the petitioner is required to be held to have superannuated from his services with effect from 30/11/2015 and for the overdrawal of pay and allowances for the period with effect from 1/12/2015 till 31/3/2017, the same is called upon, is required to be recovered from the petitioner. Also, rejoining his submissions, Mr. G.R. Datta, learned counsel for the petition, submits that the projections made by the learned counsel for the respondents that is clearly perverse. He submits that no basis has been brought on record to demonstrate as to the, Mr. Datta further submits that the respondent authorities have not revealed as to the basis on which they had computed the age of the petitioner as on 1/3/1976 to be 20 years, 3 months, 9 days. He submits that such calculation is solely based on a presumption in the matter and the same would not mandate to be accepted, and the date of birth as recorded in the date of birth and the date of birth of the petitioner is to be computed from the age of the petitioner disclosed in his Assam Madrasa Intermediate Examination Certificate 1981. Mr. Datta has further submitted that the respondent authorities are now trying to take advantage in the matter on the ground by having knowledge that the original records pertaining to the petitioner as maintained in the Guniali Guri Emi Madrasa is no longer available on the same being washed away destroyed by the floods occasioning in the month of September 1984. Also, Mr. Dr. Further has denied that the petitioner, while submitting his application for appearing in the Assam Madrasa Intermediate Examination, had made any misrepresentation therein with regard to his age. Accordingly, the learned counsel for the petitioner praised that the reliefs as sought for in the present petition be granted to the petitioner. Also, I've heard the learned counsel for the parties and also peruse the materials available on record. The service particulars as well as the educational pursuits made by the petitioner, noticed herein above, are not in dispute. The petitioner was engaged as a menial by the managing committee of GK Arabic College with effect from 1/8/1974. Also, while for forwarding the deficit particulars of the employees of GK Arabic College, comma, in the year 1976, comma, the age of the petitioner as on 1/3/1976 was recorded therein as 20 years, 3 months, 9 days. Further, his appointment as a menial was recorded therein. His initial engagement as a menial was recorded therein to have been so effective with effect from 1/8/1974. Also, the said particulars is also found to have been approved by the Deputy Director, Public Instruction, the then Deputy Director, Public Instructions, Assam, on 25/3/1976, public 77. Also, however, also, the petitioner, while continuing as a menial in GK Arabic College, comma, Guniali Guri, comma, Borpeta, comma, had submitted his application for appearing in the Assam Madrasa Intermediate Examination 1981. The petitioner successfully completed the said exam, was successful in the said examination, and a certificate to the effect was issued to him. And therein, as of 1/3/1980, the date of birth, the age of the petitioner was reflected as 19 years, 3 months, 0 days. So, basing on the said material, the date of birth of the petitioner works out to 1/12/1960. So, considering the date of birth, considering the fact that the date of engagement of the petitioner as a menial is not disputed, comma, the death said date being 1/8/1974, comma, reckoning the date of birth of the petitioner as 1/12/1960, comma, this court finds that the petitioner would have been so engaged at the age of 13 years, 7 months, 11 days. That in other words, the petitioner, while was a minor while he was initially engaged as a menial in the said college. However, from the materials brought on record, it is found that there is no disclosure that a minor was mandated to be so engaged, on the ground that there was no adult available for such engagement. But such engagement is also found to have been approved by the departmental authorities, more particularly the authorities of the Madrasa Education, Directorate of Madrasa Education, and no objection is seen to have been raised with regard to the engagement of a minor, comma, which was clearly not permissible. The said aspect of the matter, when viewed in the proper perspective, would go to reveal that, in fact, the person engaged as a menial on 1/8/1974 in GK Arabic College was not a minor, but an adult. And for the said reason, no objection whatsoever was raised from any quarter to such engagement. The said aspect of the matter is further fortified from the deficit particulars of the employees of the said college as of the year 1976, wherein the age of the petitioner as on 1/3/1976 was shown as 20 years, 3 months, and 9 days. And accordingly, calculating back the petitioner's age as on 1/8/1974 would admittedly be more than 18 years. To be more precise, the petitioner would be aged around 18 years, 8 months, 9 days as on 1/8/1974. Also, the petitioner, Saptara, the petitioner in the petition had projected that while he was engaged as a menial, has projected that his engagement as a menial in GK Arabic College was so made basing on the class 6 pass certificate produced by him in the matter. The date of birth, the age of the petitioner as recorded by the college authorities at the time of his engagement as a menial must be also held to have been so recorded basing on the said class 6 certificate. However, the said class 6 certificate is not available on records and however, the class 6 certificate has not been produced either by the petitioner, has been produced before this court either by the petitioner nor by the departmental authorities. However, it is reasonable to presume that the age of the petitioner recorded as 20 years, 3 months, 9 days on 1/3/1976 was so done basing on the disclosures made in the said class 6 certificate. In absence of any contrary material being brought on record and it being the specific assertion of the petitioner that he was offered an engagement as a menial with effect from 1/8/1974, placing on the basis of his class 6 pass certificate, this court is of the considered view that the age as on 1/3/76 recorded in the deficit particulars of the said college as 20 years, 3 months, 9 days is so based on such class 6 pass certificate. Accordingly, basing on the said age, the date of birth of the petitioner works out to 22/11/1955. Also, the petitioner having been shown the petitioner's date of birth prior to 1981 having been shown to be 22/11/1955, it is now, this court would now examine the age, the date of birth of the petitioner as worked out by him relying on the Assam Madrasa Intermediate Examination Certificate 1981. In the said certificate, the age of the petitioner as on 1/3/1980 was reflected as 19 years, 3 months. Full stop. Basing on the said age, the Date of birth of the petitioner works out to 1/12/1960. Accordingly, two dates of birth emerge in the matter, one prior to 1981 and the other subsequent thereto. While there is, while this court has concluded that the date of birth as working out basing on the age of the petitioner as of 1/3/1976 as recorded in the deficit particulars of the employees of the school at the relevant point of time. As 22/11/1955 to be so based on the class 6 pass certificate, comma, the petitioner in the present writ petition and or before the authorities in the representation submitted after the issuance of the impugned order has not brought on record any material to demonstrate as to how the said date of birth was so computed. The class 6 certificates. So, it is also not projected by the petitioner in the present writ petition that the age as disclosed by him in his application submitted for appearing in the Assam Intermediate Madrasa Examination 1981 was so based on the class 6 birth certificate and or any other contemporaneous record. Also, normally, it is the date of birth as recorded, as working out from a HSLC certificate and or a certificate issued by a board like the Assam State Madrasa Board that is to be reckoned for the purpose of determining the age of the petitioner. However, in the present case, there being two dates coming on record, one prior to 1981 and the other post 1981, comma, this court in view of the above discussions finds that it is the date of birth existing since date of birth determined basing on the materials as existing on 1/8/1974 that would mandate acceptance other than one mandate acceptance and the date of birth as working out from the Assam Madrasa Intermediate Examination Certificate being held to be one based on a self-declaration of the petitioner would not mandate an acceptance. Accordingly, the petitioner date of birth is held to be 22/11/1955 also. Reckoning the date of birth of the petitioner as 22/11/1955, the petitioner is to retire from his services on 30/11/2015. However, the petitioner is found to have overstayed in his services till 31/3/2017. Now tell me what to do. Yes, what to do? The petitioner was restrained from attending his services with effect from 1/4/2017, and the salaries of the petitioner has also not been released with effect from 1/4/2017. While the petitioner had drawn his salaries in excess on account of overstay with effect from 30/11/2015 till 31/3/2017, it is found that after 2017, till this very date, the petitioner's pension and pensionary benefits have not been finalized, nor the petitioner has been extended with a provisional pension. Accordingly, balancing the equities, this court is of the considered view that although there is an apparent misrepresentation on the part of the petitioner leading to the recording of his date of birth as 1/12/1960 in his service book, comma, balancing of equities with the questioning. To continue. Done. Comma, balancing the equities, comma, this court directs that while the petitioner shall be deemed to have retired from his services with effect from 30/11/2015, the salaries drawn by the petitioner with effect from 1/12/2015 till 31/3/2017 shall not be recovered. The respondent authorities, I'll just change this one, but this will be the thing. Respondent authorities shall compute the pension and pensionary benefits of the petitioner as on 1/12/2015 and shall release to the petitioners his pension and pensionary benefits with effect from 1/4/2017. The petitioner being now authorized his salaries for the period with effect from 31/12/2015 till 31/3/2017, the petitioner shall not be entitled to pension for the said period, and his pension shall be released to him after the computation is made as of 1/12/2015, comma, with effect from 1/4/2017. The said exercise be carried out and concluded by the petition by the respondents within a period of 3 months from the date of receipt of it. Till the completion of the said exercise, comma, immediately within 15 days from the date of receipt of a certified copy of this order, the Director of Secondary Education Assam shall authorize a provisional pension to the petitioner with effect from 1/4/2017 and release the petitioner the areas thereof. So, within a period of 1 month, however, the current provisional pension be released within 15 days from the date of receipt copy of this order.
Lordship, can it be 1 month, your lordship, instead?
If 1 month for the areas and 15 days for the current. You also sitting tight. You have not drawn up any proceedings against him. So he is entitled. And we have now protected him. 17. See how much? 8 years. Nothing. Man is hanging. He made his mistake. He's got what he is to got. There was somebody who was in love with him in that department. So they picked him up. Natural. They protected him. He has got, for 8 years, he has suffered. No more suffering. I'll just put it in the form of directions. You apply for the copy. Dispose of.
My lord, sorry to interrupt, my lord, in this. I have to leave the court, my lord, today after in the second half. So, my lord, with regard to item
Give her the number.
item number 17, my lord, my learned friend in the morning has taken time, but it was rejected, my lord. But the status with regard to the pension, my lord, it is forwarded to the treasury.
Forwarded to the treasury.
Yes.
Done. Nothing. What is left here now?
Nothing left basically, but let it come after vacation, my lord.
Okay. It is stated that the pension proposal on being approved. Comma. Paisa nahi hai. Give it to me.
PPO issued, it is sent to school has forwarded to treasury.
Lekha, it is Mr. P. Soikia, learned. a government advocate appearing for the state respondent submits on instructions that you are for the
I'm for the school, my lord,
school.
principal.
You are for the petition. What is more left?
Lordship, let be after vacation, Lordship. Mr. A.K. Bhuya is not there, Lordship.
Submitted that the pension proposal of the petitioner has been finalized and a PPO dated 17/3/2026 has been issued. It is further submitted that the amount that the same is with the has been received by the treasury, by the jurisdictional treasury officer, and the amount would be credited in the account of the petitioner shortly.
Okay.
Accordingly, in view of the above development taking place, registry to list this matter again on 27/4/2026, on which date Mr. B. Purkhaisto and Mr. P. Saikia shall apprise this court as to whether the amount has already been credited to the account of the petition.
Obliged.
A copy of the instructions furnished by Mr. Saikia is kept on record and marked as X for the purpose of I. Yes. Yeah. Where is your 75% enhancement rate that there is an order?
Yes, yes, my lord. My lord, may kindly have page 29, my lord. Annexure 4, my lord. Order dated 16/8/2000.
So the 6/4/24 to 15/8/26.
Yes.
25% is to be paid to you.
Yes, my lord. Subsistence, sir.
You're not getting back the KVP.
My lord.
Not getting back the KVP.
My lord. My lord.
Yes, you have your instructions. But the Mr. P.R. Sharma, Learned Counsel for the petition, also heard Mr.
R.A. Sheikh.
R.A. Sheikh
On
Learned
behalf of-
Counsel appearing for the Gauhati University authorities. Mr. Sheikh submits that an affidavit has been filed by the petitioner in the matter and prays that he be granted a week's time, 2 weeks' time, to complete his instructions with regard to the intentions now raised in the said affidavit. Pray accepted. Registry to list this matter again on weeks question, 3 weeks query. 5/5/2026.
Obliged, my lord.
Yes.
My senior election in another court.
Your senior was here. He wanted to have this matter, no?
Even now in court number 8.
Now we'll dismiss it. Now we don't know.
If the matter is going on, Lordship.
Huh?
Matter is going on in
You are-
court number 8.
What is the matter?
Service matter.
Service matter. Very good. Then what? Next. How long have you been in practice?
2 years, Lordship.
2 years.
Yes, Lordship.
You go to the chamber regularly.
Yes, Lordship.
Yesterday night, you did not get the opportunity to read this file. You have the file with you.
Lordship, I have. Lordship.
Don't. Second copy. Tell me the facts after 15 minutes. What is this?
Lordship, for regularization.
What is this? First, the Central Recruitment Committee. What is the concept?
Lordship, at that point of time, by accumulating the vacancies in that district, Lordship, there was a committee. And they recruited.
From where? From the road or from somewhere?
Lordship, that no record is available.
You go to the site, read the brief, come back and tell me the facts. Yes, then?
And here, Lordship, though the petitioner name was there in the list, but vacancy was not there, but the deputy commissioner recommended him for appointment. Initially, it was for another post. Thereafter, it was a reserve category. He was asked.
And he continued in a reserve category for a long time.
Yes, yes.
99,
93.
he was regularized. Not
No.
regularized exactly.
Not regularized, Lordship.
Ad hoc.
Yes.
Now, what is his status?
Lordship, going by the affidavit, at that point of time, he was 58 years.
And he was regularized with effect from 1/10/1999. Superintendent of taxes. How was he regularized?
Lordship, my instruction due to Lordship, I had not the communication number. The affidavit was there. They have stated that department that he was not regularized.
Where is the affidavit?
No, Lordship, I couldn't file it because I couldn't serve him.
We have prepared the affidavit.
Yes, Lordship, everything is ready.
No, I'll hear him. Give him the file. And why don't you give your files to him to read in the evening? Huh? Not good. Your first appointment is of 5/5/1994.
Initial appointment at 31/12/1993.
That is ad hoc.
Ad hoc. And that I had selected.
Where is your selection? Where is your select list?
This one I have not found it here.
Then how did you go before the Central Recruitment Committee?
Oh, that.
Forget your deputy commissioner's recommendation. How did you go there first?
But
That
the
me tell you.
petition is unable to find it. Long back it was.
And you're working till date?
Yeah, I'm retired already.
Retired?
Retired.
Retired as a regular employee?
Regular employee, 37.
You're getting a pension and all?
Yes.
You're getting pension?
Yes.
Huh? What do you want here then?
In this case, Your Lordship, I want regularization of service before 1994.
No, you say you are already regularized.
No, regular subsequently, instead of your 1/6/19 with effect from 1/6/1999.
Oh.
I am claiming that 25, claiming from 2/5/1999.
What is the basis of 2594? When did you retire?
Retired on 37/2020.
You're getting pension.
Yes, I have to obtain
Pension benefits you're getting.
I have to for some few days I am not contact with because phone number
Few
is
days means he retired in when?
37/2020.
6 years back. And when did you file this writ petition? 18.
It is-
Now, is he getting his pension and pension benefit?
In this regard, I have not.
Okay, call him up. Come back at the second half.
This phone number, it is not connected. So that is-
Yes, you also take your instruction whether he's been getting his pension and pensioning bill.
Okay, yes.
Third day, Lana Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on 28/4/2026. On the next date of listing, the parties shall apprise this court as to whether the petitioner, who is stated to have superannuated from his services on 30/7/2020, has been authorized his pension and pensionary benefits. And if not so authorized, the reason for the same. The Mr. Chaudhary shall also, in the meanwhile, bring on record the stand of the respondents by way of filing an affidavit.
Yes.
You file it today?
Yes.
And Mr. Counsel, next time you come before this court, I don't want the law from you. I want the facts. And 2 years is long time. I'll not spare you next time. And I'll not hear him also. You should be prepared with facts. Night you go to the chamber, take out the file, make a note. No advocate has come out without reading file. We also read and then we came up to do cases. Get my point? And don't be afraid to do cases in court. I might say like this, but I'm saying for your good, not to demoralize you, to lift you up. Just come and tell me the facts. That's all. Law, I will with my limited knowledge. Will you do? And Mr. Islam, I want to see him arguing here.
Make that I will do.
And he says that you don't give him file.
Yeah.
If that is so, we will proceed against you. Yes.
My lord, I would beg to mention item number 39. I'm an outstation counsel. It has not been heard for the third subsequent time. If it could be taken up early today. My apologies for not being in the mentioning hour.
39.
Yes, my lord.
Mr. Counsel.
Yes, my lord.
I'm sorry. From 2, we have a division bench.
Yes, my lord.
Then I still have 2 orders to pass. I don't know. Who is opposing? Yes. Where is Mr. Chakraborty?
Lordship is coming.
He's here.
Yes, your lordship.
Yes, what is your issue?
My lord, I've been unlawfully terminated. Actually, if my lords may refer to the order dated 5/12.
Give me a background.
My lord, I've been unlawfully terminated. I've been out of service for around 728 days now.
Oh, how? What were you? Who are you?
I've been accused. I've been falsely accused of misappropriation of.
Forget that. What was the nature of your job?
I joined as a faculty member.
Regular.
Yes. No, my lord, it was a contractual. Contractual. I've been.
What was the nature of that contract?
For the nature of that contract.
Means was it that appointment was made without a time limit?
No, there were certain, yes, my lord. There
were agreements being executed.
My lord, yes, my lord.
Okay.
There was a certain time limit. It was basically 1 year.
Okay, tell me the date, first date of your engagement. We are hearing it now only.
Yes.
The first date of engagement.
My lord, it is.
Oh, you tell me. Just tell me. Let me also get abreast with the facts. Just tell me the facts.
My lord, 2014, 5/2/2014, I have been engaged. So it's been over 10 years.
No. That engagement was
for 1 year.
1 year.
Yes, my lord.
So you executed an agreement?
Yes, my lord.
So it continued till 2015.
15, and every year.
Then how is it being extended from time to time?
It is a 1 year contract, my lord, and every year it is being,
yes, contract is being executed.
Yes, my lord. Yes, my lord.
Okay. When your order of termination was issued,
yes, my
what
lord.
is the date of that order?
My lord, it is 5/2/2024.
5/2/24.
Yes, my lord.
And the contract was was in subsistence till when? As on 5/12/24.
Yes, my lord.
When this order was passed,
yes,
there was a contract.
Yes, my lord.
Until which date was it continuing?
My lord, if my lords may.
Just tell me the date, Mr. Counsel. I will reframe my question. On 5/12/24, when you were terminated,
yes, my lord.
You were under a contract.
Yes, my lord.
When was that contract executed? That particular period contract.
My lord, I need to refer to a page if my lords.
Please refer and tell me. Mr. Chakraborty might have been now having a good cup of tea there, so I think we
Yes,
discussed you.
my lord. In the midst, I ran.
We discussed this.
My lord, 3/7/2023. So the agreement was made on 24/8/2023. So
With
it was
effect from
24? 24/8/2023. It was till 23/8/2024. So prior to the
When
expiry,
was the termination order?
my lord, 5/2/2024.
And when was this writ petition filed?
My lord, in a year time, I'll be exact with the dates. January 2025. Prior to that, I have completed all the services that is required from my end with the institute, SIPRT.
No. You were terminated on 5/2/24.
Yes, my lord.
The contract was till 23/8/24.
My lord.
You filed the case in January 20.
January 25.
Gritco.
Yes, my lord.
That's the end of the matter. There is no subsisting contract. You go before the court concerned.
My
under
lord,
the
we are
specific-
my lord, the
specific
primary
performance act.
contention is that we are challenging that order of termination.
You don't have that because you are a contractual employee. After the period of contract is over, how can I put back you in? Supreme
My
Court
lord,
is very clear.
My lord, I have been I cannot be just merely taken as a contractual employee. Just
That's the only facts required.
no, my lord. My lord, prior to this.
Show me any decision of the.
Yes, my lord, of this very court. Yes, my lord. My lord, we were asked to refer to a judgment.
That is it, Mr.
That is also one of.
Yes, my lord. Chand.
And you have not even challenged your termination order here.
No, my lord, we have.
Where have you challenged that order?
My lord, this is an order of the court and we were asked to refer it by Justice Saikia.
Unfortunately, you are before a wrong court. What to do?
No, my lord.
Show me your prayer. I didn't get your name.
Edas.
Please have page 17. That is your prayer. Hope it was not amended.
No, my lord.
Then where is your prayer for interference with the order of your penalty?
My lord, we are challenging the arbitrariness of this.
Where is your prayer?
But the prayer speaks.
It's a mandamus for reinstatement. How can you be reinstated if I don't set aside the order of your termination?
My lord, the contractual, if my lords may go with the contract that we have filed it in the additional affidavit.
Where is the last contract?
If my lords go by page 119. Point 4 and point 5, notwithstanding to anything.
Page 100?
19.
19.
Yes,
19. Clause?
My lords may have clause 3, 4, and 5. 3 says if my lord may have it. The engagement is purely.
Just give me a minute.
Yes.
The period was from 3/7/2023 to 31/3/24. Where is the termination order?
My lord may have it in page. Annexure L, page 95.
What happened to the criminal proceedings against you?
My lord, it has been dismissed. They have not filed, they've not yet filed their records, my lords. The matter has not been taken up in the bail order.
No, that
I have
means,
been cleared of my charges, my lord.
The
Yes.
charge sheet
No,
FR
no,
given.
the charge sheet has never been filed. my
That
lord.
means it's under investigation. You have been bailed out.
No, my lord, 90 days have passed, certainly, my
To
lord.
me, that after 90 days, a charge sheet is not permissible.
So that
Why
is
are you
something
making
that I'm
this?
not putting under contention, my lord.
You are being granted bail, maybe default bail.
My lord, yes.
That does not mean that you are exonerated from the charge.
Not at all, my lord. My lord may have the inquiry report of the department itself. It also clears me of all the charges. The inquiry report, my lord. If my
Yes, Mr. Chakraborty.
My lord.
What is the nature of the departmental inquiry held against him?
My lord, he was contractual. So
Forget it. You say that there is some departmental. What is that
yes,
departmental?
I'm showing, my lord.
Was he paid to participate?
Yes,
Was
my
he
lord.
allowed to
My lord,
participate?
I'm just pointing out the date. My lord, a committee was constituted. Annexure 4 of my reply, first show cause notice gone. He has given a reply. Then another show cause notice was given, creating a larger period. That also he has given a reply. Then he was invited that you are showing something, some documents, and you want to see some document, come to office, verify everything. On 3-4 days, he has verified the document. Then he has given a reply. Thereafter, inquiry committee held, going to the thing and held that he has misappropriated the amount, my lord.
No, my
So
lord.
enough of opportunity, my lord.
My lord. My lord, that inquiry never took, the inspection never took place because it was just an inquiry. And also, my lord, I was
Now,
transferred.
show me the decision that after the passing of the
In
there
final
being no-
inquiry, my lord.
No, there being no contract subsisting on the date you approach this court,
Yes, my lord.
that this court would have the jurisdiction to entertain the writ application.
My lord may have.
They're relying on some judgment.
My lord.
What is that?
My lord, also, I would like to put into the notice of this court, my lord, that prior to this inquiry, I was not even in the place where the inquiry was conducted. And also, my lord, all the records were kept with the
We'll come to
principal.
that. We'll come to that, Mr.
Yes, my lord.
Thus, we'll come to that.
My lord, my lord.
But first, show me the
Certainly.
query.
I'm referring to another judgment of this very court. Yes, ma'am.
See, in Masood, there was a condition in the contract that the provisions of the Assam rules would come in.
My lord.
So the court held that
My lord.
this is done. Here, this is a case of clear no. This issue of with regard
My lord,
to Gridco had not been gone into in both the cases.
My lord.
Gridco was discussed in Masood's case by my Lord Justice
Sham.
He
Yes, my
had
lord.
discussed it.
My lord, yes.
But
ma'am.
he found that the clause with regard to termination, the
My lord.
manner, that was not followed. So he interfered with that.
My lord, what I'm challenging in front of my lord is the stigmatic order of the very termination. My lord, and also, my lord, if my lords may have
we have got it.
final
That's
inquiry.
Other than this.
My lord, I have a few other, but it seems
Please.
if my lords permit me some time, I can have it in front of my lords.
Oh, you're having it. Give it to me.
It is there. I need to get it printed out, my lords. It's been a long flight for me all the way from Delhi, my lord.
You are here today.
Yes, my lord, I'm very.
We'll have it in the second. We are disposing it of. Problem.
My lord, may kindly go with the final inquiry, the inquiry report. That is.
First, satisfy me,
my lord,
that after a contract is over, I can reinstate you.
The contract.
I'll give you the decisions of the Supreme Court which says to the contrary.
My lord,
right from Gridco onwards.
my lord,
And there are decisions of this court also.
my lord,
My own decisions are there.
my lord.
So you are stuck there. Anyway, you are coming from outside, you have expressed an urgency. We'll take it up. Just satisfy me, take me
My
out
lords,
of this
if-
point. You take me out of this point.
My lord, I will certainly try my level best. But my lords, if you may reflect to the final inquiry, that is all I need from this.
You get your
Cases and
case loss. One hook. We'll have it. 2 o'clock, I have a division bench. And then we have 2 matters to pass. Pass those orders and then come back to you.
my lord.
We have heard it. Now nothing is there. You place those judgments, Mr. Counsel.
My lord,
You're coming from?
Delhi, my.
You place your judgments.
My lord, if my lords can just have a glimpse of the inquiry, that is all I require from
Why
this.
a glimpse? I'll go deep into it.
My lord, if my
I'll
lords
go
may have
deep
it now,
into it.
I shall produce the documents, whatever, my
sorry.
lord.
I'm not taking it casually.
My lord,
I
my
may look
lords.
very casual, but I'm not taking it
No,
casually.
my lord, sir.
I have want that issue which are there.
My lord.
First is whether this can be maintained.
My lord,
If yes, we'll go into the issue of the manner in which the proceedings were.
my lord,
If I am satisfied in the first point itself,
my lord,
why should I take the trouble of going to the second point?
my lord.
Yes.
My lord, we seek for some time to produce certain relevant judgments from the
It
Supreme
will be
Court.
granted, but with cost. It's on your insistence that I took up the matter, wasted 20 minutes, leaving my dictation. You said you come from outstation, I
My
accommodated
lord,
you.
very true.
If you want it, pay a cost.
My lord, if my lord can just hear a plea from my own personal side, not from the other side, my lord, it may a significant time. I'm not requesting for any significant time, but some time. We have placed certain judgments in front of my lords, but certain Supreme Court relevant judgments can be placed.
That you should have carried if you're wanting for a disposal.
My lord, this is what happens when you learn with experience, I'm sure.
Come on, Mr. Just never repeat this with this court again.
Sure, my
I
lord.
don't like it. If you want to take it up for disposal, I'm ready. You made a plea that I'm not being heard. I'm an outstation counsel.
My lord,
So I accommodated you.
yes, my lord.
Right?
That is
And
very
now,
true.
when you saw the view of the court, now you want to take an adjournment.
That is.
Lekha. Heard the learned counsel for the petitioner. Heard Mr. Adas. Learned counsel for the petitioner, who had insisted for an out-of-turning hearing in the matter. Accordingly, the said prayer was granted and the matter was taken up for hearing in the first half. The hearing not being concluded, the matter was directed to be taken up in the second half as the first item. When the matter was taken up in the second half as the first item, Mr. Das has prayed for an adjournment. So the matter being taken up by at the request of the petitioner, learned counsel for the petitioner, who had projected that he, being an outstation counsel, would seek an indulgence of this court, which was granted. They said step taken by the petitioner is not appreciated by this court. However, a prayer for adjournment being made, the same is granted. Registry to list this matter after 6 weeks on a date to be fixed by.
Much obliged, my lord.
How should we remember this member?
You have got your note ready?
Lordship.
Nothing more to be heard.
Yes,
We have heard from both sides. Can you give the note?
Note, Lordship.
Tomorrow. No. Give me on 20th. No problem.
Lordship, 20th, I'll give. Otherwise, Lordship, just the 1 point clarification part, Lordship. In the advertisement, it says that, Lordship, a PhD degree in the concerned allied relevant discipline in the institution concerned with evidence of published work, Lordship, and research guidance to a defined component, Lordship. That is the reason.
Basically, you have dismissed this case on the ground of research guidance, not on the ground of published.
Published, not issue published. Published, here's the publications.
The learned counsel.
Even Lordship, 2000.
Hearing concluded, registry to list this matter again on.
Yes, sir.
12/5/2026 for delivery of orders. The parties are at liberty to bring on record their respective written arguments if so advised.
Lordship.
May it please your lordship, my lord, I being the respondent, my lord, who was removed. Now the secretary has filed an affidavit annexing some documents, my lord, controverting for which is required from my side, my lord. Because the affidavit has been filed by the secretary supporting the petitioners, my lord, that I have refused, some directors have refused.
Mr. P.K. Roy Chaudhary, learned counsel, prays that he be granted for the 2 weeks' time to bring on record. To bring on record a rejoin, to receive instructions with regard to the contentions made in an affidavit filed by the
secretary.
respondent number 4. Prayer is not objected to by the learned counsel, for the other parties. Accordingly, registry to list this matter again on 7. On 28/4/2026, matter be not treated as parted and or
Number 1.
matter be not treated as parted and or it was in a yeah. Mr. Edeka, learned counsel.
I'm appearing from TK Bhuyan. My name is not in the cause list.
We heard you, we'll have
Hello.
to write you.
Hello.
Edeka, learned counsel for the petitioner. Mr. T.K. Bhuya was never near you on that day. Learned counsel for the petitioner appearing on behalf of Mr. T.K. Bhuya. Heard Mr. Edeka, learned counsel, appearing on behalf of Mr. T.K. Bhuya, learned counsel for the petition. Oh. Also heard Mr. P.N. Sharma, learned standing counsel, elementary education department, and M.U. Mahmood, learned counsel appearing for the respondent number 8. The present petition has been instituted by the petitioner, assailing an order dated 18/7/2023, issued by the Director, Elementary Education, Assam, whereby the claim of the petitioner for provincialization of his services under the Act of 2000 came to be rejected. Also, the petitioner projects that he was appointed as an assistant teacher of Besimari Girls Hostel, ME Madrasa, wide order dated 27/1/2001, issued by the managing committee of the said school. Order dated 27/7/2001, issued by the secretary of the headmaster of the said school, and he had joined his services on 30/7/2001. Also, after the enactment of the Act of 2012, the case of the teachers of the said school, including the petitioner hearing, was taken up for consideration for provincialization of his services. Also, why did you make a respondent number 8 here a party? You have no grievance against him now. You can have no grievance against him.
My only submission is the matter means in disputed question of facts.
No, there is no dispute.
Matter may refer to the educational tribunal because this.
While the said process was on, disputes arose between the petitioner herein and the respondent number 8 and a question had arisen as to who amongst them would be required to have their services provincialized. After several rounds of litigation, the matter was considered by a coordinate bench of this court wide in the proceedings of WPC number 3996/2018, instituted by the petitioner hearing, along with another writ petition being WPC 4489/2016, also instituted by the petitioner hearing. So the coordinate bench of this court, upon considering the issues arising in the matter, was proceeded with judgment and order dated 19/7/2018 to hold that it is the respondent number 8 who is senior to the petitioner herein, and accordingly, the provincialization of the services of the respondent number 8 under challenge in the proceedings were not interfered with. Also, the writ petitions instituted by the petitioners were dismissed. However, the coordinate bench provided a liberty to the petitioner hearing to submit a fresh representation before the authorities with a prayer for provincialization of his services. And it was further stipulated that if such an application is made by the petitioner, the same shall be considered on its own merits and in accordance with the Act of 2017. The petitioner being aggrieved by the judgment and order dated so and so 19/7/2018 had assailed the same before the division bench of this court by way of instituting a writ appeal, being writ appeal number 213/2018. The writ appellate court, upon considering the issues arising in the matter, proceeded with order dated 11/4/2019 to dismiss the writ appeal as being devoid of any merit. However, the division bench reiterated that the case of the petitioner hearing may be considered for provincialization under the Act of 2017 if an application is filed as indicated by the learned single judge in the judgment and order dated 19/7/2018. Also, the petitioner is thereafter found to have submitted an application for provincialization of his services in Besimari Girls ME School. Also, the said application was considered by the Director, Elementary Education Assam, and after noticing the history of the litigational history of in the matter, proceeded to hold that on a verification, it was found that the enrollment position of students in the school, as per the DICE data for the years 2016-17 and 17-18, was found to be 87 and 67 respectively. Also, accordingly, it was held that the school of the petitioner was eligible to have services of teachers serving therein, was eligible to have the services of 3 teachers working therein provincialized. under the provisions of Section 3, bracketed 1, bracketed 11 of the Act of 2017. However, 6 teachers in the said school were found to have been already provincialized. Accordingly, the prayer of the petitioner for provincialization of his services was rejected. Also, Mr. A. Deka, learned counsel for the petitioner, at the outset has submitted that the rejection of the claim of the petitioner for having his services considered for provincialization under the Act of 2011 has since attained finality on the had attained finality on the division bench of this court in writ appeal number so and so, Asana, affirming the decision passed by the learned single judge by judgment and order dated 19/7/2018 in WPC number 3996/2018 and 4489/2016. He, however, submits that the learned single judge as well as the division bench in their respective decisions having granted liberty to the petitioner for submission of application for consideration of his case for provincialization under the Act of 2017, such consideration cannot be an empty consideration and has to be so made strictly in accordance with the provisions of the Act of 2017. He submits that the respondent, that the director, while proceeding to consider the claim of the petitioner, had only reckoned the position with regard to student enrollment for the years 2016-17 and 2017-18, whereas in terms of the provisions of the bracketed Roman 12, such verification of the enrollment position of students is to be so reckoned for the last 3 years, that is, the last 3 years prior to coming into force of the Act. He submits that the respondent authorities had not considered the status with regard to the enrollment of students prior to the year 2016-17. Accordingly, he submits that a due and fair consideration of the case of the petitioner not having been extended to him, the order dated 18/7/2024 would mandate an interference from him. That's only argument?
Yes.
So, the said prayer is objected to, disputed by both the Learning Standing Council, Education Department, Secondary Education Department, Elementary Education Department, and Mr. M.U. Mahmood, Learning Council, appearing for the I've heard the learned counsel for the parties and peruse the materials available. As noticed here in above, the claim made by the petitioner for having his services provincialized, either in replacement of the respondent number 8 and or from a date from which the services of the respondent number 8 was so provincialized, has already been rejected by this court, and the said position has been rejected by this court by a coordinate bench of this court, while judgment and order dated so and so 19/7/2018 in WPC number 2001, which was affirmed by the division bench of this court in Writ Appeal number 213/2018, which has since attained finality. Accordingly, in the present writ petition, this court is only required to examine as to whether the case of the petitioner was considered by the Director of Elementary Education, Assam, for provincialization of his services under the provisions of the Act of 2017 in terms of the liberty extended to the petitioners by the coordinate bench of this court, while judgment and order dated so and so, and reiterated by the division bench of this court in WA number, in white judgment and order dated so and so, passed in WA number, so it will be WA number so and so. Also, this court has perused the order dated 18/7/2024 passed by the district Director Elementary Education Assam, and finds that the case of the petitioner was rejected by holding that the student enrollment position in the school did not mandate further sanction of additional posts to the said school in terms of the provisions of the Act of 2017, read with the provisions of the RTE Act 2009. Also, while the said contention, basing on the said conclusion, the director proceeded to reject the claim of the petitioner. The rejection of the claim of the petitioner being on the ground that there was no student, that the student enrollment position did not mandate further extension, further sanction of additional posts, the petitioner in the present writ petition has not brought on record any material to dispute the said position. Also, the petitioner, the writ petition has after reiterating the litigation history of the matter, has not made any submissions with regard to the conclusions reached by the director in the impugned order dated 18/7/2024. So, in absence of any material being brought on record to dispute the conclusions, basis for the conclusions drawn by the director in the impugned order dated 18/7/2024, this court is of the considered view that the said order would not mandate an interference. Mr. Decca at this stage had submitted that the non-inclusion of particulars with regard to the students, enrollment status of the students was an inadvertent mistake on the part of the counsel for the petitioner, and the petitioner be not made to suffer on account of the said position. Also, considering the said submission of the petitioner, this court provides that in the event the petitioner is so advised, he would be at liberty to institute appropriate proceedings, subject to the plea of limitation being raised before the jurisdictional educational tribunal in terms of the provisions of subsection 2 of section 19 of the Act of 2017. Also, in the event the petitioner institutes any such appeal and therein brings on record materials to justify the brings in materials highlighting the enrollment status of the students for the relevant years in terms of the provisions of the Act of 2017. The tribunal, in the event proceeds to consider the same on merits, shall limit its such consideration only to the provincialization of claim of the petitioner for provincialization under the Act of 2017 and in no manner shall consider and disturb the provincialization already affected and affected in case of the respondent number. Right? With the above observations and directions, the present writ stands disposed of.
Right.
Yeah. Yes, nothing more?
Lordship.
You have got the records with you?
No, Lordship.
Mr. You have not brought the record, you have not still brought the show cause and all those things, no?
No.
Inquiry report, nothing?
No, and the show cause is there.
Where?
No, not please, before Lordship.
Nothing is here. I'll dismiss it on that count only.
I suppose to your Lordship,
You had asked me for 10-15 minutes today. I'm giving you. But where? What is your? Nothing is here. Your criminal case acquittal will be of no use. And we don't know whether the lady appeared before the inquiry officer. Mr. Sajid, I don't want to be technical. Too technical man's job is there. Seems to be the first offense. You get the records after the vacations. Mr. R. Chetri, Learned Counsel for the petitioner. So the matter was listed for delivery of orders today. However, Mr. R. Chetri, Learned Counsel for the petitioner, has submitted that the inquiry officer had drawn his conclusions in the inquiry report, dehouse the materials coming without reference to the materials coming on court. However, he submits that the inquiry report or the show cause notice for the show cause notice is not made part of the records. Also, this court in the present writ petition does not find any such contention being raised by the petitioner in the matter. However, for the ends of justice, this court directs Mr. A. Chakraborty, government advocate, to produce the records pertaining to the proceedings instituted against the petitioner, wide issuance of which had led to the issuance of the order dated 25/4/2024, imposing upon the petitioner the penalty of dismissal from service.
Lordship, kindly, he is not challenged that dismissal order, Lordship. Lordship. Only reinstate.
Registry to list this matter again on 6/5/2026 for further hearing.
Obliged, Lordship.
Yesterday night I felt bad. That's why I put it back. Let my conscience be. You are not bothered. Let my conscience be at least clear. That's it.
Obliged.
Mr. Dasgupta, what are you waiting for?
The retail benefits belongs have been paid.
Nobody has appeared.
The Nayak is there, my lord.
His name is not shown. But
He was there. The lordship might fix a date and then. 38, no? The gate for employee, my lord, order was passed in the year 2024.
clear-cut directions, but still not complied with.
The last occasion, Mr. Nayak appeared.
I'm sorry, his name is not shown.
Today also he was present. Anyway.
We'll have it after vacation.
All.
But Mr. A. Dasgupta, Learned Counsel for the petition. So Dasgupta, Learned Senior Counsel submits that on the last occasion, Mr. Nayak had appeared for the respondents. However, it is seen that the name of Mr. Nayak is not reflected in the cause title for the respondent. Accordingly, registry to list this matter again when?
Any date.
On 2026. 20 will not be a okay, 2026, reflecting the name of Mr. P. Nayak for the response.
My pleasure.
Please, your lordship, my senior is often like at another.
As paid for by the Learned Counsel for the petitioner, registry to list this matter again after the Bihu vacations.
Not it may be fixed.
Would it? Yes, what is your instruction?
Lordship, look, we already filed one affidavit here, Lordship.
Yes. Yes.
Lordship, we are praying for reinstatement, Your Lordship, here. Lordship, there's a clear violation of mandate as held in Amit Chaudhary
Yeah,
judgment, Your Lordship.
that OM Lordship, that we, that thing is that if you cannot distinct, if you file the charge sheet within a period of 3 months, then 6 months extended Lordship, that we can get as part of.
We'll hear it. Today before vacation, this matters cannot be done.
Master's.
On the prayer of the Learned Counsel for the, this is tied up matter, no?
No, single matter.
Learned Counsel for the petitioner, for the parties, registry to list this matter again in the last week of April to.
Master's.
May it please your lordship. Lordship, in this matter, we need 3 weeks' time to file our affidavit, lordship.
On the prayer of Ms. P. Sharma, Learned Standing Counsel, APSC, matter stands adjourned for 3 weeks. The Ms. Sharma shall ensure that the affidavit on behalf of the respondents represented by her shall be brought on record before the next date of listing. Also, registry to list this matter again after 3 weeks on a date to be fixed by.
Much obliged, lordship.
In this case, my lord, the pleadings are complete, my lord. Only, my lord, the dismissal order, my lord, challenged by the petitioner, my lord.
Well, hear it. What is that?
Yes, my lord. My lord, the dismissal order, my lord, page 30.
It is submitted by the Learned Counsel for the petitioner that the pleadings in the matter is complete. Also, accordingly, admit the petition. Accordingly, issue rule. Issue rule. Writ petition stands admitted. Registry to list this matter for hearing in the month of June 20.
My humble submission, my lord, during my lord, service tenure, my lord, this petitioner, my lord, applied, my lord, as per the my lord, SSC exam, my lord, for the post of sub-inspector, my lord. Accordingly, he was qualified, my lord.
No, but the misconduct is now proved.
Yes, Lordship.
Well, here,
That is why, my lord,
Okay.
I have annexed this, my lord, in the, my
on
lord.
the Mr. Ellen
May
Dehi,
first, my
Learned
lord.
Counsel for the petitioner submits that the pleadings in the matter is complete and accordingly the same may be taken up for disposal. Also, prayer accepted. Registry to list this matter again on
May 1st, my lord.
14/5/22.
Obliged, Lordship. Please. In this case, my lord, today private respondent has filed affidavit also. Today. Oh, my lord.
Your name?
D. Gogol.
Mr. D. Gugoi, Learned Counsel for the petitioner, prays that he be granted 2 weeks time to file a rejoinder to the affidavit filed by the respondent's number.
Private respondent number.
Private respondent number 4, 6, 7, 8, 9, 10, 11.
By the,
10.
by the private respondents.
I for 5, 12, 17.
You have filed your affidavit?
Yeah, we have filed, but it's not on record.
Okay, let us come. You have also filed today?
Yes, so we have also filed for 1, 2, and 3. PTC is also filed.
But to the affidavits filed by the respondents, Koidia. To the respective affidavits filed by the respondents.
Well, if required, my lord, I think not required. If required. If required, Lordship.
If so advised.
Lordship. Deeply blessed.
List after 4 weeks.
May I please, Your Lordship? Lordship, item number 19, there was an interim.
Huh?
Item number 19, there was an interim that may be extended, Your Honor.
Continued key using.
It was listed after verification. Your
Extend Koidia. Interim order passed then, if any, that's extended till the next date of this.
applies, Lordship.
May please, your lordships. Lordship, in these two connected petitions, lordship, the petitioners have suspension order dated 22/8/2026. Lordship, otherwise the pleadings are complete. They have filed their affidavit, and in their affidavit also, it has been made clear that the authority who had suspended us had no power to suspend us, lordship.
Okay, it is submitted that the pleadings in the matter is complete. Accordingly, registry to list those matters again on 11/5/2026 for admission hearing.
Lordship, there is an interim protection.
Interim order passed earlier, which in both cases
Yes, lordship.
to continue till the next date of.
I'm obliged, lordship.
Non-appeals for the petition on for the ends of justice, registry to list this matter again after the ends of vacation.
May please, lordship. My petitioner participated in the recruitment process, my lord, but he was declared unfit in the medical examination.
Ready for disposal?
Yes, my lord.
Petitioner, you are not filing an affidavit in reply.
No.
The Learned Counsel for the petitioner submits that he would not be filing any rejoinder to the affidavit filed by the respondents. Accordingly, pleadings is complete. Registry to list this matter again in the 3rd week of May. Or
Can it be earlier, my lord? Recruitment already they have published the result, my lord.
2nd week of May.
Obliged.
On a year, on 7/5/2020.
Obliged, my lord.
My lord, B.Ed without permission, principal in charge, TC school, my lord. Item number 30, the hearing report is at page 54. 54, my lord.
Only this much. And your name is? Mollika Devi. And Subbalakshmi is junior to you.
Junior to me.
Yes, Mr. Hello. What is this?
The only difficulty, my lord, against that order, my lord, that is passed by my lord Justice Chaudhary, my lord, we have preferred an appeal. So
there are a number of orders passed by me also.
Yes, true. But
I'll be bound by my order.
And that appeal, my lord, is on the subject of whether DP can be proceeded against employees who had persecuted BH.
Whatever it is.
That is a separate cause.
My order, Pankaj or not, then the whole thing.
starting from Mosumi.
Mosumi is by my lord Justice
Bujabura.
Taking a cue from there, I had passed this order. So, Mr. Sharma, I'm not doing anything before the vacations. They're keeping it for further hearing.
My lord.
Immediately after the reopening, we'll discuss. Did you? So that one. I find like a good, yeah. 28.
I'm grateful, my lord.
Party Learned Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on 28/4/2026 for further hearing. Which is positive.
I'm ungrateful, my lord.
Yes, Mr. Ali.
Oh, shit.
Mr. Dhar.
My lord, we will file an affidavit in this matter. Now he is retired. He is no more in service. And there is, my lord, huh? If it already, my lord, a report from DC, I believe it is there, my lord. They are in the record, my lord. On the last occasion, my colleague has submitted before your lordship. So, my lord, we would like to file an affidavit to this effect.
Nothing is here. Thing is there. It's all hanging. Your case is that you were prematurely retired.
No, in the service book, my lord, date of, as per service book, my lord, his date of retirement, my lord, in
2026.
lost. No, 2033, my lord.
33, huh?
33.
Same issue. In the regularization order, there is a different date. From where did you get that? Mr.
My lord, I will get that. There was even a similar case my lord has dealt with 2 days back of PWD.
This is also PWD.
Similar case. Because in the regularization order, my lord, regularization order is always based on some documents. Once a proposal.
We want that document.
Yes, my lord.
You're saying that will not do. Huh? Say today, it's a case that his age is reduced by 10 years. Right? When you come up before us, we'll say, no, you have done it on the basis of some documents. You proceed with that date only. Will it be acceptable to you? Similarly, your mere saying will not do. There has to be something. But Mr. R. Dhar, Learned Counsel for the Learned Standing Council, PWD, prays that he be given a last chance to complete his instructions in the matter. Mr. Dhar, full stop. Mr. R. Ali has expressed urgency in the matter. Full stop. However, considering the prayer of Mr. R. Dhar, a further opportunity, as the last opportunity, a last opportunity is granted to the respondents to bring on record their stand. In the event the stand is not so brought on record by the next date of listing by the PWD respondents, this court would proceed to consider the issue arising in the present petition basing on the materials already available. List on registry to list this matter again on 6/5/22. No more further time. Right. Heard Mr. J. Loscott, Learned Counsel for the petitioner. Mr. Loscott submits that on account of a medical emergency arising in the family, he is required to leave the court. Ito ba sign ko rin siya Honey, so and so. Prayer, accordingly, he prays for an adjournment on the matter. Prayer accepted. Registry to list this matter again after 2 weeks on a date to be fixed by interim order, if any, passed earlier to continue. Interim order passed earlier to continue till the next date of listing. It is silo by heaven. Really. 24 for good. On 24. None appears for the respondents, please.
Lordship, the act for service report, Lordship, official
Uh-huh.
dated 4/4, Lordship, 2026, office note 4/4. The respondent number 11, 12, and 13. And Ahmed.
Registry to await completion of certificates upon the respond number 11, 12, and 13 for further 3 more weeks. It's gone only on 19th.
No, Lordship, earlier on many occasions, Lordship, time has been granted to take steps, but my learner has not taken steps. It is reflected in the last order. Now, also here issue is Lordship, the repetition is not maintainable. Here the issue is the advertisement is for promotion from the Anganwadi helper to Anganwadi worker. Here the petitioner is neither an employee or nor a Anganwadi helper. So she just spread that to this proceeding, Lordship. The Lordship, the handle government notification, Lordship. The 25% is the promotional post and the 75% is the fresh post, Lordship. Without follow the guidelines, Lordship.
Okay. Come to the guideline.
Lordship, the page 21, Lordship, type table, Lordship. The page 22, Lordship, the bold, Lordship.
No, where is the state government guidelines?
The Ministry of the Home and Child Development.
2013 notification.
No. 13, huh?
Yes. My learned friend.
Therein, Mr. Dhar, just check up. The recruitment is limited to the posts available in that Anganwadi center and other Anganwadi center in the revenue village, right? Is there a stay order?
No.
No, Lordship.
Because of pendency, Lordship, my promotion order is not issued, Lordship. Already, Lordship, we have
File an application, we'll clarify that.
Lord.
3 weeks, this, 2 weeks.
After 2 weeks, any date, Lordship.
2 weeks.
Huh? Say, go to read it.
There is a stipulation. That
Yes. That's 2013.
Find out that number of vacancies. given
Lordship,
to me, we'll
today
discuss
Is there 7 number of vacancies?
7.
Yes, we are working
The
there.
Lordship, the total.
And how many, then 7 means 25%. 7 out of 7, 25% will go to promotion. Now, how many posts are put to direct recruitment?
The only, Lordship, the application received only 7%, Lordship, and the selected 7%.
Page 29, Lordship.
Okay, we'll see.
Obliged. No, affidavit did you? 35, my lords. That person is working. I have his appointment, these letters. Here where he joined, my lords, this transfer orders.
See, Gugoi, on instruction submit that the petitioner on being repatriated to the forest department is continuously holding post in the department since the date of his
My lords,
repatriation. However, there being none to represent the petition, the matter stands adjourned. Registry to list this matter again after 2 weeks.
and any salary proposal also has been sent, my lords, areas. Yes. 36 to Kiev. Oh, my lords. It's transferred.
Better non-payment of DCRG, Lordship.
Paid.
Not paid, Lordship.
Yes,
Lima Hasa, my lords.
we are not there. Notices have been served.
Notice, issued, Lordship, notice served, Lordship. Mediation failed.
Mediation, let it fail. You have not even taken steps. Have you taken steps?
Lordship.
When did you take steps?
Name of the council of SC demands of son, Lordship. And AG also.
You D. Gogoi, R. Borpujari, J. Gogoi, SK Medhi. You are getting your pension,
Pension is getting, Lordship.
but only the DCRT
DCRT,
is
Lord.
not. Show me the direction.
Lordship.
Direction of this code.
And it's not a-
No, WPC.
Not called WC.
Yes, who is the authority? DCRG is given by whom?
Given by the department, but it's a sixth schedule matter that's been transferred to them. The Mahasab.
There is a heard the Learned Council for the petitioner. Also heard Mr. D. Gogoi, Learned Standing Council, PHC. You are appearing, you are not there, na, Mr. You are not there. There is no representation on behalf of the behalf of the Dimo Hasao Autonomous Council and the Accountant General. Accordingly, for the ends of justice, registry to list this matter again on 23/4/2026.
Master.
Someone did it.
Well, some time may be granted, my lord. I need some verification, my lord. Here, director needs some verification from the SSM, my lord.
Mr. P.K. Bora, Learned Council for the petitioner. On instructions
Contempt, my lord.
that he be granted further 2 weeks' time, 3 weeks' time to complete the processing involved for compliance of the directions passed by this court by judgment and order dated 6/9/2024 in WPC number 5398/2022. So, the appellate order has not been issued. Appeal has not been disposed of. No. 2 weeks. Mr. Bora, on the next date of listing, shall place before this court the compliance report. Also.
For disposal, my lord, this verification is required, my lord, from the SSM.
Verification you do if it's
Yes,
not
my
done.
lord.
We cannot. We passed this order when? 21/9/24.
24, my lord.
It was done on 6/9/24.
My lord. 6/9/20.
3 সপ্তাহ করলো না 2 সপ্তাহ করলো? 2 weeks, huh? 2 weeks, huh?
Blessed.
So we'll write next time, asking them to come. Appellate order not passed. The director is not having the power to get the records. Nobody is listening to her or him, whoever it is.
Bless me, I'll file your bill.
None appears for the petitioner even on second call. For the ends of justice, registry to discuss matter after ensuing bifurcations. Same.